You are ready?
Yes, we are ready, madam.
The complainant is here. So,
Complainant, I have filed with information.
Complainant is.
He has sent some communication.
no, he's also, I'm told he's in the registry को पूछो.
So you don't have a copy of it.
हाँ?
Yeah.
वो जो नागालैंड के बारे में.
It's filed also.
We do not have, madam.
We do not have what's expired.
There is some kind of a memorandum filed by him. There is a
No,
memorandum filed by him.
Yeah. No, he. I'm told that he's at the gate, so we have permitted him to come inside.
Let him
पूछो.
also
Huh?
assist.
So we'll ask him whether he's just on the way.
Yes, madam.
Yeah,
Whichever way, madam, your lordship comments.
So we don't.
Give them copy also.
तो दोनों को copies दे दो.
Yes,
You don't have copy. He has filed some kind of memorandum.
I don't have it.
I am also not.
So we'll fund.
But be that as it may, madam, it's essentially a question of law.
Question.
Despite our
Give the counter by Lokpal.
Yes,
That
that we
we
have.
Yes,
That we have. That we have.
that is almost reiteration of the order.
Order.
That's correct.
But in my view, Lord, only one section of the Lokpal Act is to be examined. Whether, my lord, the judges of the constitutional courts would fall within public functionary or not. That's the only limited question.
I'd like to go a little further with that, sir.
That, my lord, I may, my lord, till the complainant comes. But the limited issue is whether the Lokpal has the jurisdiction. In case of complaints against the honorable judges, what should be the method, what should be the mechanism?
There's already a mechanism in place.
The mechanism, but that's not the issue, my lord, right now. Therefore, my lord, let us not expand beyond the scope of Lokpal, my lord, jurisdiction.
वितत तो क्या कर रहे थे उसको बोलो ग्रेफिक इमीडिएटली बुला लेना.
Syria dedicated.
But I just received the written submissions of Mr. Sybil, quite illuminating, but it is more traveling. What should be done, my lord, if Lokpal is not the authority? Whether
That's not
the
an
chief-
issue now.
That's not, my lord, in my submission, the remit of this bench. Whether the Chief Justice's view is binding, what should be the impeachment, etc. That may have no relevance in the present scenario.
You should have seen this question also.
I think Malad is the complainant.
Either I. Is there a file? Aye.
I have already written what I wanted to say, Your Honor. What all I have reduced to writing, but I want the honor of the Lokpal and also judicial to be uplifted. That's our request, sir. I put everything, whatever I wanted to say in writing, sir. Can you kindly be considered?
If you want legal assistance of some senior advocate free of cost, we will
Not
provide you
necessarily.
free legal aid if you want.
I don't require. What all I have put it in writing may kindly be considered.
We'll consider whatever are your submissions.
I have put it in writing. My memo of written submissions, Your Honor.
But still we consider that, you know.
We request you. No, because he has some different viewpoint. Though he doesn't want anybody's services to be offered on his behalf. Could we request you, because largely the learned solicitor as well as Mr. Sibal and Mr. Marlapalle are on the same page. If there is some other viewpoint, can you assist us? Because we don't want. I think that's because. So,
Entirely your lordship.
Yes.
You can assist us as an bikers.
We can also give another point of view,
Yes,
we
but-
can give you
Yes,
both
but we
points.
are not taking
so
sides.
but we know that you are not taking sides, but still.
I'll give you both points
Yeah,
of view,
so-
there are issues.
So we'll request Mr. Ranjit Kumar to go through his
Yes, yes.
submissions and all that, and then so that
Yes,
we
yes.
every viewpoint is considered before we decide.
Yes, I agree entirely with you.
In all fairness, it may not look as if only one
Absolutely.
side.
Yes, absolutely, you're right, absolutely right.
Absolutely.
And
So
In fact,
we'll
we
furnish.
will give both sides, but again, my lord, at the cost of repetition, the issue, para to para, my lord says, the learned Lokpal, my lord has said.
No, we will only consider the issue with regard to jurisdiction.
Jurisdiction under the Lokpal.
Under the Lokpal.
Section 2O, read with section 14(1)(f). That's the limited question.
Yeah.
Yes. Yes, ma'am. No, certainly, but that would be for the purpose of deciding whether Lokpal has the
No,
jurisdiction.
Maharaj, in fact,
Not what should be, where should it go, etc., etc. That's not, my lord, the
in fact,
remit
the
as I.
fundamental issue will be, can a complaint be ever filed outside the remit of the constitutional authority?
I
That's
fully
really
agree,
the
my lord, that's
fundamental
the-
issue. Correct,
That's-
correct,
that's
correct. Now,
correct. We are
can
at
somebody
item.
go to the police station and say, register an FIR? Maharaj, I'm just putting the issue. That's why I said it is a larger issue as my lord put it. And we need to, Maharaj, address your lordships on that.
Yes, my lord, only, my lord, one thing, the question whether somebody can go to a police station and register an FIR against, my lord, a constitutional court's judge also, again, not a subject matter.
Maybe so, maybe so.
There are, my lord, judgments which are occupying the field,
Maybe so.
and that's not the remit of this court.
Maybe so.
Therefore, I would earnestly request, if need to be gone into, my lord, we'll assist. But that's not the question, my lord, being required.
I'm
Okay,
sorry.
what should be done? How the police will consider, whose sanction will be taken?
No.
We have Viraswamy judgment, sanction of the learned Chief Justice. Well, these are not the issues under consideration.
Anyway, I will make my submission. Not an issue.
Any date, my lord, my lord's convenience.
Yes, any.
Because 3 benches will have to, my lord, break. So, my lords,
Was
no, maximum one session.
Yes.
so on some day we'll keep it in the second half so that the other benches are also not disturbed.
Yes.
Yes.
We can constitute a special bench also of the remaining 3 judges so that some work is again.
And, I have filed my written submissions, but I may file a consolidated submission in advance so that your lordships can go.
I will also moderate my submission in the context of what's followed.
Yeah, that will be, it's, yeah.
We going to ask the registry.
The notice issued by the complainant is personally present in the court. He has already filed an affidavit in support of the submission. On being on specific query being put to him as to whether he would like legal services of a counsel from the legal aid. The complainant says that whatever his submissions are already recorded in his affidavit, and therefore he does not need any legal assistance. However, with that as this, we find that it will be appropriate that in addition to the learned senior counsel already assisting the court, we request Mr. Ranjit Kumar, the learned senior counsel, to act as an amicus curiae and assist the court. Correct. Our request is graciously accepted by Shri Ranjit Kumar. We direct the registry to furnish a copy of all the pleadings to the learned solicitor, as well as Mr. Sibal, Mr. Marlapalli, and Mr. Ranjit Kumar, the learned senior counsels. Could we give it on 15th? 15th April
Please,
at 2 p.m.
yes. Only one request, if it pertains to the lawsuit, now that the learned amicus is also there, no further I is needed.
No. Correct.
Yes, absolutely.
We,
No, otherwise there
yeah.
will be.
live streaming.
That's the problem.
The matter is directed to be kept on 15th of April at 2 p.m. That we will not record it.
Yes, sir.
Can you also direct the registry, because they don't take our submissions because they do advocate on record.
Yeah.
So when
Sorry.
ask them to take our submissions.
Yes.
Yes, the registry to accept the submissions of all the aforesaid four counsels are filed through their respective assisting counsels.
Should we tell that man that we have masked his name?
You must have seen our earlier order. Mr. Complainant.
Sure.
We have marked your name.
Yes, sir.
Yes.
Should you tell my name?
No, it's not necessary for us because we just wanted to protect your identity.
Because I don't want to put my name because.
Yes, sir. So we'll protect your identity. We'll keep your name masked only. Yeah. So, and we'll consider whatever cause you are trying to expose. Yes. So you need not, if you don't want to say anything more, then you need not remain present on the next date.
I'll present, no problem. If the pleasure to be present here and
Or if you can join online, whatever you choose to.
I'll personally present.
You are from Delhi only.
I'm not from Delhi, but still no problem. I
Okay.
can come down to this court, honorable court. As a courtesy, I will come as
Thank you.
the honor, an opportunity to appear before this honor session.
He should even entry for a name.
15th April is the next day.
No problem. I can come down, no problem.
Yes, in the past also it will have to be passed. Yes. Obligatory.
This, your lordships, my lord, I directed the registrar, my lord, give a report. The registrar has given a report. The small discrepancy, which is a everyday cost. Any day that is convenient to your lordship, my lord, I only request that it be on high on board.
What is it about?
This is a land acquisition matter, my lord, where your lordship, and this is the second round in the land acquisition matter, where your lordships had directed the registrar, my lord, to hear all parties and give the calculation. Calculation matter.
Karnataka matter.
That's right. And they have not, now the report has been submitted to your lordship. Bro, after hearing all the parties, in fact, I may say the registrar has convinced the parties also, bro, in respect of the calculations. Now, there is a small discrepancy insofar as the beneficiary is concerned, where there is an everyday cost. Therefore, there is the urgency.
It's already listed on 1st of April, I think.
Very well. If it could be taken up high on board, but it won't take very long.
Not to be delayed, high on board.
I am very grateful.
My lord, this matter was listed on 2nd of December. By notice was issued, it has not been listed thereafter. It was mentioned also, it was listed on 11th February.
It's now listed on 17th of April.
My lord, it will be too late because NET registration has started. My recognition has been withdrawn. Your lordship, while issuing notice, had observed that my compliance report was not taken into consideration and they are in violation of section 16 of the Dentist Act. So my lord had issued notice returnable 4 weeks. Now service is complete, they are also not filing counter. I'm requesting first week of April if it is convenient.
Then about you.
803 are the NEET PG matters which were getting listed before your lordships. Lords on the 3rd, and then it was to be listed today, but it could not make it to the list. Lords, I'm requesting we be taken up next week.
Oh.
And
It's already listed on 24th of March. 24th of March, not to be deleted.
Because I appear for the petition, Lords. Lords, on the last date, the husband had sought 45 days time for making the final payment, Lords. I have received information that the amount is, my Lords, ready. Therefore, my Lords, I'm requesting if your Lordships can have it this Friday.
Listed on 7th of April, so not far away.
So in the order sheet, my Lords, 14th of April is being reflected. If your Lordships can have it,
It shows at 7th of April.
then Lords may have it on that date, or if your Lordships have it.
Not to be deleted.
Not 7th April. Okay.
That is showing for the 26th.
Yeah, not to be deleted. Yes. Not to be deleted.
And on my item number.
Correct. Beg your lordships kindly, please. List of mentionings are over.
Yes, yes.
Lord, this is 101 on Thursday's list. Suddenly fine, my lord. I'm ready. I have a personal inconvenience in the foregoing session. I didn't want to inconvenience your lordships on Thursday.
No, but then I think Wednesday and Thursday that NABA and LIT will go on those electricity matters, so they not reach also.
Well,
Because we have requested them to conclude them by Thursday latest.
Last Commission may I mention that coming on 20th, 114 years, I am in personal difficulty. I have LLM exam learned on that day. 1 day accommodation.
Okay.
I'm so great. 114. I will not teach asking the sitting, but I will request you to pull in accommodation and inform the other side. Item 47 today.
47 today.
It's that forest matter Karnataka Lords HMT and
HMT and yeah.
Yes, it's come up. It's come up. It was supplementary yesterday, right? So
Union versus state.
I request for a 2 weeks accommodation and inform the other side. The
Mr. Sival is also appearing.
I note my item numbers.
Yes.
My item number 70 is listed today, but as per the sequence, it is too far. And it's admission matter, and I mentioned on 4th of March it is listed, but it didn't reach. So my request kindly, it is take today.
Let us see.
Item 44 is that contempt matter, your lordships. It's the last matter on the list today. and Lordships has a special matter also fixed. If I may request your Lordships to fix it up high up on some date, your Lordships. Because this requires the house of the petitioner, your Lordships, is under this thing. It's securitized, your Lordships. Now he can't live in the house.
Is that patrimonial matter?
No, your Lordships, this is the contempt matter with regard to the payments not being made after the company was hived off to someone else. That matter where the legal question with regard to whether there can be a review of the contempt in sentencing part, your Lordships.
From Delhi High Court.
Yes, your Lordships.
We'll sit on some other day because if we don't know whether if it reaches today,
I
then
request your Lordships, if Lordships fixes it up in the first
you ask
five matters.
someone to mention it in the second half.
Very good. I'll do that. Great.
Under item 11, your Lordships have directed the matter for mediation. The mediation is still taking some time, my lord. In fact, just yesterday, the respondent had traveled to Hyderabad to meet the petitioner wife. And they've had a hour and a half long conversation.
So we'll keep it after 4 weeks.
Item 12 asking me some time to file counter affidavit. Counter affidavit is ready, my lords. In due course, I'll file it, my lords.
My lords, this matter, your Lordships may kindly see, my lords, we've been really troubled. Every time we are released on bail, my lords, a fresh FIR is registered by the state. I have a chart. Please see the chart. Stale allegations of almost 6 months old, 2 years old, my lords. Every time it comes up, my learned friends.
Notice is issued in the November, we are in March.
My lords, kindly have it next week, my lords. My counter affidavit is ready, my lords, but my lords, it will not be filed. In due course, I will file it, my lords.
Can I just hand over this draft for your Lordship?
From January, you are taking time to file counter affidavit.
My lords, I can understand, my lords, the counter is ready, my lords.
What are you doing from January?
There is some data that's my lord, it has to be corrected, my lords, then it is prepared, my lords, or everything is prepared, my lords, it's ready to file it. In due course, I'll file it, my lords.
We'll have it on next Monday.
Next week, my lords. I'm much of this, my lords.
Yeah. The Learned Counsel for the state submit that the counter would be filed during the course of the day.
Yes, my lords, during the course of the day.
During the course of the day. Post the matter on next Monday.
Lords, in this matter, that there are 3 accused persons, Lordship. 2 accused had already been granted. I am in judicial custody since 18/5/2024, Lordship.
1 year.
1 year.
9 months, Lordship. 9 months, 12.
9 months, sir.
And the role of assault is also attributed to you.
Yes, your Lordship.
Approximately 10
In
months.
fact, Lordship, with my counter affidavit, I have annexed the photographs of the head injury. It's a 3-inch deep head injury, Lordship. Kindly see page 19 of my counter.
No, we just show only the simple injury, Lordship.
Lordship, there's a finding by the doctor which says that it could have resulted in death. Lordship, kindly have a look at page 19. It's a 3-inch deep head injury right in the middle, Lordship. And he is the primary accused.
No, this injury is attributed to him.
Yes, your Lordship. And upon his indication, the iron rods have also been recovered from his own premises. He's only undergone 9 months, 27 days, Lordship. And the vital witnesses are yet to be examined, and he's
No,
not.
Lordship, only one witness, the complainant, has been examined, but he had not identified.
Yes, state criminal. Whether injured has been examined.
Yes.
No, Lordship, there are 2 injured witnesses besides this.
The case has been examined, Lordship.
Both
We have
the
not identified the accused.
Yeah, we are not inclined to.
The examination.
We are not inclined to entertain the present application at this stage. However, the petitioner would be entitled to renew his request in the event the trial doesn't conclude within a period of 6 months.
Lordship, no, only one witness has been examined, Lordship. Kindly, he had not identified the accused, Lordship.
6 months.
I'm most grateful.
What's match 14? I'm requesting that it may be called on Friday. There are 2 cases against the accused. I just wanted to get the status of those, and after charge sheet, what is the status of the trial? He's been in for 1 year so far, my lords. If my lords may call it on Friday, I'll have these details.
My lord, as far as the other two cases are concerned, I've been instructed that both the cases have been compounded, my lord. I'm not-
I just want to confirm that because I don't have.
Yeah, next week.
Well,
In item 15, my lords, I am appearing for the petitioner. My lords, the Section Court and the High Court rejected the regular bail, citing the 164 statement, my lord. Despite the fact all the material witnesses have already been examined and all have turned hostile, my lords. I have no criminal antecedents, my lord. The injury, the report, the official report says that the injury is not is found on the body of the deceased is not possible by the bamboo. And that has been annexed in the FSL report, my lord, page 34.
Yes, have you filed a reply?
Yes, my lords, it's not right.
So what do you say?
My lords, there are three things, my lords. First of all, my lords, as he says, there were no injuries. There were injuries from the knife as well as from the bamboo stick. This petitioner is the main protagonist. Everything started from his house. There was a quarrel at his house. Then they went outside, starting searching for the deceased. Thereafter, they attacked the accused. There were two eyewitnesses, my lords. In this 164, they were admitted everything. Thereafter, my lord, due to circumstances, they don't want to take any enmity. They turned hostile, my lord.
Have you placed on record 164 statement?
Yes, my lord, it's there.
Yep. Counter देना. 164 Yes, page number?
My lord, it's 49. The English portion starts from 51, my lord.
Read Hindi.
This is Bharat Bansod. He's one of the eyewitnesses who was with the deceased at that time when he was attacked. He was also attacked. They were sustained injuries, my lord.
Both have turned
If I
hostile,
may, my lord, this is 164. They turned hostile because of the reason they don't want to take any enmity.
There is no such explanation in that evidence.
There is a recovery from the petitioner as well, bamboo stick and the bike from which they were roaming around.
Your name is first.
Yes, my lord. But if your lordship will see the
main
page number 39 of the SLP paper book, they have turned hostile, my
Yes,
lord.
so that shows even if after remaining inside you can be so powerful.
But my lord,
What you can do?
I am student, my lord. I have no criminal antecedents.
Even otherwise,
I have no criminal antecedents. All accused have a criminal antecedents, my lord. I have no criminal antecedents. Also, my lord.
Whether any of them has been released on bail?
My lords, no, because they have a active role. One can see, my lord.
Yes, Mr.
Bambode. Role, my lord.
This is
If your lordship
302.
They were responding as well.
If your lordship will see the weapon which is attributed to me, the FSL report says that the bamboo seized cannot be the injuries found on the body of the.
Within how much period the trial will conclude?
My lord, only 10 witnesses have been examined, my lord. Total
12 witnesses have been examined, my lord.
Total 34 witnesses.
So we are not inclined to entertain the application at this stage.
My lords may kindly consider few aspects, my lords. My lords, then allow me to withdraw.
Yeah, allowed to withdraw.
I think I need to clarify two issues, Your Lordship. Paragraph 6, because what is paragraph 6 at page 4? What is raised with the High Court was that the central government has issued a clarification. While the Puducherry amendment came later, paragraph 6 at page 4.
Yes.
According to the petitioners, central government has clarified the position upon the anomaly arising as a result of the proviso to section 26, not carving out an exception for the situation. No other authority could have gone into such aspect of the matter. Though it's quite irrelevant in the context, it must also be recorded on behalf of the Union Territory Puducherry. Submitted the letter of October 26, if central government is of no effect, as such order is contained letter of Soncha has not been laid before the House of Parliament in accordance with the mandate of section 113. Also submitted in a response the judgment Allahabad High Court relevant date, the purpose so is now the subject matter of the before Supreme Court with it as it's made. So that's how it is weighed with the court. I think I should place the order Allahabad High Court and the matter that it does not place before the Parliament. We're going to place those records. You'll also proceed to discuss the matter thereafter because I'm sure Allahabad High Court to dispose of the matter and an appeal has probably also been disposed of. And let me place that. Regardless of that, the authority of the Puducherry, Union Territory of Puducherry to amend the rules is available under section 109.
No, but whether the rule-making body can do something beyond the statute.
It is in that context
So forget about Allahabad High Court.
No, I'm talking about the central government rule. Central government says, I clarify the position because there's something to be clarified. It is not as if the position was very clear.
Come to para 12, please.
So I don't take any exception to the proposition. But the problem arose in the context of the fact that there was something which was required to be handled. So what is the appropriate date? Therefore, the Union Territory had the power under section 109 to frame a rule to resolve this issue. In that context, the Union says I've issued a clarification, which clarification ought to become law, must go before the Parliament. So let me place those documents, we'll also take a call on that thereafter. If that going to finally govern the situation, then let it be so. For section 113, there will be clarification ordered if any within a period of 2 years, it will wait before the Parliament. It has not been taken to the Parliament.
Let me say this. About 19 years back, my land was acquired. Till date, no award is passed. Lordship, may kindly see page rule number 109. It specifies what can be amended under the Act, my lord. Now the government says, I will amend the date of the acquiring notification anterior to the 2013 Act. In Indo development,
I'll address the arguments on that question. I will address the arguments on that question.
Kindly see, under the rule, my lord,
it is not as if
109, my lord, the rule making
page.
Right to Fair Compensation Act.
Then right to fair compensation.
Your Lordship knows that the rule-making power will always have two components. For the purpose of the giving its effect to the Act will be one broad component rule-making can be made. Then there are enumerated powers. The enumerated powers may not deal with this question.
Admittedly, this power is not there under the rule-making.
Let us see 109.
109 section. Power of the appropriate government to make rules. Not even a single word that the date of notice.
That's why Lordship will know section 109. Like every rule-making power will have two broad components. One, the first subsection will always say to carry out or giving effect to the purpose of the Act. Then there will be enumeration. The enumerations will not govern the main purpose of the rule-making power. That will not govern that. Therefore, I'll place judgment to the effect also.
No, subsection 1 says the subject to
what I will do is, I'll place judgment to the effect as to whether this can go to the extent of saying.
This matter has been adjourned so many times.
I'll place some judgment to the effect.
It has been
As far as subsection 1 is concerned, what's the extent of the power available?
Some outer limit for adjournments.
I understand that. So, but the problem with that isn't because the central government tried to say, I will clarify it. So in essence, what I see is the rule-making power of the Union Territory of Puducherry, where it feels it is a problem, and the central government issues a notification.
What provision this is permissible?
No, may do it. Give me a little time. I'll place those authorities on record, and also to show that the union government's clarification has not been laid before the Parliament. Therefore, so that is a vacuum. Who will
but that was always there.
I place all that. You will not give me.
That was always there from the very beginning. It was there. You should have
not there. That's why the central government clarified it.
In which year your position of your land has been taken?
I place the central government clarification.
This is unjust for a union territory. Somebody's land is being taken in 2006 and you don't pay compensation for
compensation paying is not a question. The question is what will be the effective date, because it's got a problem for every acquisition. It's not only this particular acquisition. Therefore, we have to deal with that question. It's a matter of general principle. So just let me place it so that I'm satisfied able to satisfy your lordship.
You deposit the amount under compensation.
No, I'll ask them to deposit. Yeah. Let it be deposited.
Not only one thing. Lord, Indo Development Authority 2013, your lordship considered, Lord, under that they say, if the award is not passed under the earlier act, then 1/4/2013
that
is
question
the
doesn't
date.
arise here.
That's what my prayer, and that prayer is allowed, Milord. They say we will issue an award. Then they come back and say, no, we will change the date of the notification to 2006. Then again the High Court, I file a petition on a second round of litigation. That documents are not filed before lordship, then I filed it, Milord. The High Court says you have given undertaking that under the new act you will file
Let
an
the
award.
compensation be deposited, no issues at all.
12 years since the new act has passed. 19 years since my land has been acquired.
It's standard 4 weeks at the request of the learned Attorney General. However, in the meantime, the petitioners shall deposit the amount payable to the petitioner towards compensation on account of, as per the provisions of the 2013 Act.
Get
Sometime we will not.
4 weeks are already
As
paid.
it is possible, I don't think.
4 weeks.
Yes, sir.
But Allahabad High Court, the lordship has already dismissed SLP, which my
I'll place all that.
This will have the same fate.
At least the money would be safe, secure. Will
And
not
at least now you don't have to go and run after them for your award and money.
The senior citizen aged about more than 18.
That's why it's secure now.
It's a deposit, not so that I will take this. Let the amount be
After that, after the money is deposited.
After your lordship has said about that if the permissions are not granted and non-existent objections are taken, your lordship will pose the cost of 10 lakhs rupees. Now, what is the issue today? Very simple. If I am a college, my lord, which is running MBBS and I start PG courses, I can always seek increase, my lord, before the 3 years of the first batch. So there is no stipulation in the entire act and the regulation, admittedly, that if you want to either start a new PG course or increase in PG course, you are not to wait for recognition of PG course first. Because, my lord, your lordship gave a judgment in 2016 that every year you are monitored. So you are not to wait for 5 years for so-called formal recognition for starting a PG course or a new course. Now, my lord, in both these cases, they have held the colleges to be ineligible on the ground that you have been given the PG permission in some disciplines with some seat capacity in 21 or 22. In 23, 24, you are not eligible.
For the same course.
For the same course, you are not eligible. And application is not considered. I go in appeal to the central government, send it back to NMC. NMC rejects in March again.
Let us show that.
Now, let us see that, my lord. First of all, your lordship may kindly see item number, my lord, 50. And my lord, let me your lordship hand over, because the only question which is to be asked is there any condition of pre-existing recognition for PG courses for you not to consider the case for the increase or for start of PG course? Kindly have a look at these, my lord, before I go to the.
This is 3 matters. My lords may look at all 3 together with the same institute.
I will show that, don't worry. 50 something new, 49.
49 is the one that we had yesterday, if your lordship.
Yes, let us have 49. 50, my lord, if your lordship may have it first, my lord. Item 50, my lord, your lordship may have it.
49 will.
Doesn't matter, my lord, the point is common. I am showing your lordship the legal position first. Please hand over the paper. Admittedly, my lord, let my learned take instruction, no requirement for recognition of PG for starting a new PG course or for increase in the admission capacity.
Actually, we have also not marked item 50. That's why I was requesting a 49 paper book, your lordship.
Come back to 49.
You come to 49 first.
Very well. In that 49, your lordship may take this meeting in paper book in 49. Now, first judgment of your lordship is in Balaji.
first judgment, my lord. This is, my lord, when the regulations had provided. This is a judgment, my lord, 2016 1 STC 434.
Hmm.
434. If your lordship may kindly come to the first page, my lord, the first judgment, para 5. This is, my lord, when the regulations are required that you should be recognized in the UG code, that is in MBBS, before you start, my lord, the PG code, number 1 or 2 situation. Starting of PG code after you are recognizing UG course. That's for first position. Number 2, if you have started a PG course, you wait for 3 years for recognition of PG code, and only then thereafter you can ask for increase. 2 situations. They were existing in the regulation. Your lordship said this is wrong understanding. Please, my lord, kindly come to para 5. Kindly come to para 5. It is clear from the scheme of the Act, as per the relevant provision extracted above, the recognition and permission are 2 different concepts. Recognition is of a medical qualification, ordinarily known as course conducted by an institution which is also to be recognized. Para 8. Para 8, my lord. In short, permission of central government is required to establish a medical college to open a new course of study or training other than the recognized course, and to increase the admission capacity in any course of study or training. However, recognition of the central government is also required for the medical college and the course of study for the purpose of medical qualification. Once a medical college is recognized under 11 with medical qualification, thereafter, for increase in the admission capacity in any course of study or training that is recognized under Section 11 of the Act, only permission from the central government as per scheme under Section 10A is required. So once you are recognized for MBBS, for any increase or for starting any PG course or for increase in any PG course, there is no further recognition which is provided, and that's a wrong understanding. Kindly come to para 11.
No, on the contrary, it says, once a medical college is recognized under Section 11,
yes,
then what is required is only permission under Section 10A.
16 recognized in 21.
So do you have a permission under 10A for increase?
Permission is granted first, then I go for 5 years, I'm inspected for 5 years every year. I'm granted in year, then I'm recognized in 21. Thereafter, I started PG courses in some discipline. Now I want to start in some other discipline and increase in the discipline where I started after 21. So what they say, which discipline I permitted you in 22, you will complete the PG course in 25. I cannot permit you for increase in those courses because you are ineligible. I am showing 2 things to your lordship. When their regulation has provided recognition also at that stage, your lordship has, for your understanding, is wrong. Now the regulations are done away with. When the government has rationalized that you can be given PG courses even when, my lord, your first batch is in the second year of MBBS course. That's the new law from 2023. They are applying that law in only few cases. Wherever they don't want to give, my lord, they say for ineligible. Please see, my lord, now. Kindly see para 11 under the scheme of the Act. Para 11. Permission is for the admission capacity. And
para
11.
Under the scheme.
Yes, my lord. Under the scheme of the Act, permission is for the admission capacity and recognition is for the course and institution. Once a course and an institution is notified in the first schedule as per Section 11 of the Act as recognized course and a recognized institution, the admission capacity of its increase in any recognized course needs only the permission of the central government. Now, my lord, kindly see 2 more paragraphs. Para 17. The decision dated so and so is one taken by the committee, and to increase the strength in any medical college unless the existing strength is recognized by central government. As we have discussed here in above, the Act does not provide for recognition of the admission capacity in a recognized medical course for a recognized course. The opening of new high course of study or training, including an increase of admission capacity in any course of training, including postgraduate course of study or training, also do not contemplate such a requirement. So, my lord, your lordship done away with, explained and told the NMC, now there is no requirement of any recognition after your MBBS is recognized. Now, my lord, this is followed. The judgment is followed, my lord, by the Delhi High Court in 2020. The second judgment, my lord, of Delhi High Court, para 26 of that judgment. IDC para 26. NMC's primary opposition is that since the petitioner college had accepted increased the seat capacity of 50 seats from the academic year 21-22 onward, it can only be considered for further increase after grant of revised recognition for said increased intake of 50 in terms of Regulation 5 of the Establishment of Medical College Regulation 2019. On this aspect, judgment of the Supreme Court in Sri Balaji, my lord, which I read to your lordship, my lord, Union of India becomes pertinent, wherein it was held that permission and recognition are two different aspects. Permission is for change in admission capacity and recognition is of a college and an institution. A medical college, once recognized, is only required to obtain permission for enhancement. There is no merit in so and so, my lord, the contention is rejected. Now, my lord, kindly see the change in the regulation. But the new regulations have come in 2023, my lord, which is now bringing the situation in line with the judgment of your lordship. So, my lord, it is in item 50, my lord, if your lordship may kindly come, the regulations have been placed along page 49 in item 50. Page 49 at 51, the new regulations of 2023, which, my lord, starts at page, my lord, 43. 43 2023 regulation which have come into force on the date of the publication. Kindly see, my lord, 51, chapter 3. Kindly see the topic. Establishment of postgraduate medical institutions, starting of new postgraduate medical courses and maintenance of standard of education. So, my lord, with regard to PG courses, kindly see 3.1, permission and recognition. No medical institutions have started any PG course unless granted permission. Right, my lord, which your lordship have seen. Now, kindly see, my lord, the second part of subclause 2. Second part of subclause 2, my lord, the subclause 2 is in 2 paragraphs. Kindly come to the second paragraph. We start with the sentence, the medical college institution will be permitted. The lordship got it, my lord?
Yes.
To start PG course if it fulfills all the requirements for running the existing undergraduate course. That's it. If I can continue to provide, my lord, for the MBBS course, there are completed, my lord, MBBS course, for my starting a new PG course or increase in the admission capacity, there is no requirement of waiting for any recognition further. Please see further. The medical college institution can apply for starting the PG course 1 year after the medical college has been permitted to start an undergraduate course. Please see the shift. Earlier, you have to wait for 5 years for MBBS course, then recognition is granted, then my lord, you can apply for PG courses. The amendments which have been made, my lord, as per the government policy from 2016, earlier, my lord, made you eligible to apply in the 4th year of the MBBS course. Now it has been brought down to 2nd year of the MBBS course. I read the sentence again. The medical college institution can apply for starting the PG course 1 year after the medical college has been permitted to start its undergraduate course, that is, during the 2nd year of the undergraduate course. So for applied PG, I need not even complete 5 years of the MBBS course. Now kindly see subclause 4. Please see subclause 4, just below that. Once permitted, the course for the qualification will be considered recognized. What your lordship held, my lord, that once you are testing everything and granted permission, what is the concept of recognition? Concept of recognition, my lord, is utmost respective, that you fulfill all the requirements in part that education, therefore you are recognized. Your lordship said, with the permission to be evaluated every year, and a person gets permission every year, after the 5 years of the work.
Where is your permission for the PG course?
Now, kindly see, there are 2 categories. One, my lord, I have to apply for PG course to start it. Other is, my lord, to ask for increase. The 2 cases, my lord, have both. In some cases, it was allowed with the particular seat number, and I asked for increase which they have held to be ineligible. I am not eligible because the courses with the seats which are permitted in PG, you have to wait for 3 years. You will get a recognition of PG course, only then you can apply for increase. And even in those cases, my lord, where, my lord, I am applying for the first time in that PG course, they say you are ineligible. What ground? Not know. Only God knows, my lord, what is the ground. Now, my lord, this is the legal position 3.2. One more clause, 3.2. Increase of seats. So, my lord, you can apply even in the 2nd year of your MBBS course. And when can you apply for increase? Procedure, method and criteria for increase of seats will be the same as prescribed in 3.1 above. That is in the 2nd year of the MBBS course itself. Provided an increase of seats as granted, as already recognized postgraduate courses shall be deemed to be recognized post courses, seats for the purposes of registration of the student. Now, earlier what used to happen was, after the PG 3 years are completed, you will get a formal notification of recognition. Now that also is done away with, that even if there is no recognition after 3 years, that is not required. The law provides for a deemed recognition of any such institution for PG courses, and those students who have got PG degree from such institution are deemed to be possessing a recognized degree, and therefore they are entitled. Now, my lord, if your lordship may kindly see this writ petition itself. Kindly come to my lord. Page number 73.
49.
Yes, item 15, my lord. Item 50. I'll come to 49 in a moment.
Page number?
Page number, my lord, 72. I'm sorry, 73, which is 7th of February 2025 order. This is 7th of February. And kindly come to para 4. The college has applied for starting a PG course of emergency medicine with 4 seats for the academic year 2021-22. Letter of permission was granted by the letter of 25/5/22 for starting a PG course with 4 seats for the academic year 21-22. So this problem never came then, that you have to first of all get some recognition, only then you can come. No, everybody understood. Kindly see the next paragraph, why it is declined. It is to inform you that application for starting of seats in the said course has been examined and your application does not fulfill the eligibility criteria. Now, which is that criteria, my lord? Somebody has to guess. It does not fulfill the eligibility criteria. Eligibility is, I am a recognized college for MBBS. I have been permitted, my lord, seats in some PG courses. I want to increase there or I want to start some new PG courses. Now, my lord, this, then they consider this, my lord, first appeal. This is the original decision, my lord, which is on the top of 74. Then kind
if it is already granted for 21-22.
Well, 21-22, it was granted earlier. I applied for increase. So the NMC says you are not entitled for increase because your 21-22 has not completed 3 years. It is not recognized. They don't even say that. They only say you are not eligible. Now this is the.
So insofar as 4 seats are concerned, that is not that.
Going on.
You want an additional seats.
Because I am entitled, I applied, I fulfilled the criteria.
Under what provision you are entitled to for NS seats?
The same regulation which I showed to your lordship.
No, it is not automatic. Enhancement is not automatic.
No, I think you have to apply.
You have to apply, but your application doesn't mean that they have to automatically grant you.
But they can't reject it that I am not eligible.
You ask them why which party? Why is it even rejected?
The regulations that they are relying on have come in December months. December 2023. So if your lordships will now have item 49 months, because all annexures are compiled along with the petition.
Let us see 49, I show 49 also.
Not some of the annexures in the writ petition. Otherwise, it's a compilation of 200 documents with writ petition. So if your lordships will kindly have, item 49. What they are essentially, the crux of the matter is, in 2023 regulation, the requirement of recognition has been done away with. Now this regulation comes on December 2023. The advertisement, the public notice inviting colleges to apply for increased seat comes on 16th of August 2023.
No, the regulations come in December 23.
So in August 2023, the regulations that are in force are the regulations of 2000. And that we have said in the public notice. Kindly have the notice, item 50. The notice starts at page 71. It is otherwise.
You want to go to 50 or 49?
Got confused. My colleague kept on saying.
You should not be, guided by the way towards confusion. Or his voice is enough for page 50.
My lords, may kindly have the writ petition starts at 23 and page 71, my lord. Page 71 is the public notice which was issued on 16th August 2023. My lords have page 71. So this is a public notice pursuant to which, my lords, we have sought, lordship may just permit me to read the first line. Subject is applications invited for postgraduate course, for starting new postgraduate courses, not in super specialty courses, new courses, increase of MD, this is where they come, increase of MD, MS, DM, MCH seats for academic year 2024-25, and the date is from 16th August to 15th September 2020. And now kindly see at this notice itself, my lords, page 86. That's a portion of this public notice. We specifically say that it will be the regulations of 2000 which will apply. At page 86, my lords, second paragraph.
Balaji does not deal with increase of seats.
Balaji then deals with MBBS courses where the regulation does not require your recognition. I will take your lordships to that.
Balaji does not deal with PG.
No, my lords. In fact, Balaji says that the regulation does not have this condition. So how can you add this condition by way of a committee recommendation? I'll show that.
Increase of seats for existing course in medical extra.
My lords may see para 2 at page 86. All applications will be considered to be amendments in the new or higher course of study 2000 of the erstwhile so 2000 regulations. So we have categorically said
if you read page 87, it specifically deals with increase of seats for the existing portion in medical institutions. Please read that text.
My lords may see, it starts at 87, but kindly come to page 90, my lords. Page 90 is the postgraduate.
No, we are saying something in your favor. Please come to page 87 2. No medical institution shall increase the seats
Without prior permission of anyone. Please, my lord, I'm grateful. Kindly also have page 90, my lords. Para 2.1.2. Sub-para 2.
No, without prejudice to anything, it's so and so. The application for an increase in the seats shall be accompanied with consent of affiliation from the recognized university, concern for the proposed numbers, such prescribed application fees, so and so. So whether they are having a COA of the concerned university.
Consent of affiliation.
From the, so there must be a, you are from which state?
There is no difficulty.
You are from which state?
These two colleges, one is in Telangana, other is in West Bengal.
There is no difficulty on this, my lord.
So they do have COA along with the application for
Please, my
increasing fees.
Kindly have, my lords, page 90 for a minute, my lords.
Yes.
Para 2.1.2, that's postgraduate application, and kindly see sub-para 2, my lords. All applications for the year 2024-25 will be in accordance with amendments to the minimum requirements regulations of 2000, and then the medical council increase of admission capacity regulations of 2000. Which are the regulations which require that there should be recognition of your existing courses? That they did not have. Now I'll show to your lordships the letter of disapproval. These lordships have seen the public notice. 16th August the notice comes, and the closing date is in September. The 23 regulations come only in December. Well, pursuant to this notice, public notice, large number of colleges across the country applied. The petitioner himself has put a list of more than 50 colleges, hundreds of seats. And now the admission process is at the fag end. The PG admission process for the academic year 2024-25, for which the classes also started in December 2024, has finished all the rounds of counselling. Now we have reduced the percentile by 5 percentile, and there is a mop-up round that has taken place, and it's at the fag end. So to introduce new seats, it can't be done for only one institute, this was by way of a public.
According to him, it has been done in a discriminatory manner. Some have been granted and some have not been granted.
It is our respectful submission. My lords may permit us to file an affidavit on that. It was just listed yesterday.
So are you making a statement that no institution has been granted increase?
My lords, no institution has been granted increase in terms of the 2023 regulation, which is what he's asking. All institutes have been dealt with in accordance with the regulations in force on 16th August 2023, which is the regulations of 2000. So whoever had recognition of the existing courses, my lords, existing intake, they alone have been allowed increase if they fulfilled other criteria. That is the condition.
So they have a permission and not recognition.
I'm sorry, my lord.
They have a permission for 21,
Please, my lords.
but not a recognition.
Please, my lords. And which is required under the 2000 regulations.
Let's-
Kindly also see, my lords.
Shows that regulation.
My lords will have to see the combination for that. Permit me to show the letter of disapproval in this case, my lords, at page 66. And then I'll take your lordships to that regulation, my lords. At page 66, this is how it has been rejected. This is the letter of disapproval. And over the page at 67, your lordships may just note column number 2, my lords, and column number 13. Column number 2 is date of last NOP, that is letter of permit for PG seats, applicable for increased seats only.
Column number 2.
It's column number 2 and column number 13.
Date of last LOP.
That is letter of permit, my lords. So 7/9/2022, as per NMC website, they started their PG course on 7/9/2022. So not eligible for increase intake for the year 2024-25. And my lords, kindly see the column 13. Committee reviewed the standard assessment form and scrutiny form of expert, and all relevant parameters not found satisfactory, so decide to disapprove increase intake of PG courses to MD radio diagnosis on so and so. If your lordships will now have a compilation that my colleagues had.
There is MD radio, but his application is for, I think, that emergency medicine.
There are 3 PG courses. That is why I was requesting that there are same 3 petitions by the same institute for 3 different PG courses. Well, I only marked 49 because the connections were like.
Yeah, but The cases are identical, but for three different specialties.
Three different specialities. Subjects are different. But it's all increased. And my lords, your lordship can record our statement that none of the colleges across the country have been permitted on the 21st. Now this year they will apply. This is a process we do every year, my lord. So this year when we...
Shows the regulation under.
My lord, there's a compilation my colleagues handed over yesterday.
Yes. Balaji compilation. Yes.
My lords, what will apply to them? I will take your lordship specifically to that, my lords. It's at page 20, my lords. The relevant portion is at page 20. Can we hand over our...
We have the opponent. Yes.
Page 20, my lords. This is part 2 of the regulations, of 2020 regulations, my lords. Scheme for permission of the central government to increase the admission capacity in any course of study or training, including postgraduate course of study for training. And then your lordships will see para 3, which is the qualifying criteria, that medical college institutions shall qualify to apply for increasing the number of admission in MBBS, PG, so and so in the existing medical college if the following conditions are fulfilled. My lords, have that with me, my lords, and
yes.
Kindly now see over the page.
He is recognized by the Medical Council of India.
Kindly see para 1 and 2 is not, so just the last blue portion, my lords, foot of the page, this is the portion. So your lordship will also see that the regulations are changed from time to time. 2009, it was a different regulation which provided some exemption from some of the subjects, autonomy, physiology, etc. 2016, there are some other amendments. Then 2018 amendment is the one that your lordships are concerned with, which continued till the 2023 regulation came, my lords. That is the last para at page 21. Above clause has been further substituted with the following in terms of notifications published in 2018 Gazette. The medical college, medical institution shall be entitled to make an application to increase admission capacity for MBBS PG diploma courses once the concerned qualification against the sanctioned intake has been granted recognition under section 11(2) and now section 35 of the NMC Act and included in the first schedule. So they did not have this recognition, my lords, and therefore, my lords, they did not. Now they are saying you brought in the new regulations, consider under the new regulations. They will be considered under the new regulation, but for this year they will be considered. They can't be considered if they apply, my lords. We will issue a public notice around the same time, but we can't apply these regulations singularly to this institution.
Are you having a recognition under 11(2)? Are you having a recognition under 11(2) of the old line? No, yes or no?
One case.
No, yes or no?
The regulation do not require.
Yes, dismissed.
Let me just take 1 minute.
No, thank you. Thank you.
Here, if 1 second more.
Yes.
Where courses started in 21 and 22. In 21.
Thank you, Mr. We are impressed only with the discrimination parties.
Show the discrimination.
You show us any of the colleges who have been granted increase under the new regulation.
Page 135. One.
And if you find it incorrect, then it will be dismissed with cost from 1 crore. No. We are specifically putting a query to you.
No.
Good. Can we complete the query? Yeah. You please point out one case wherein you have been denied the increase on the basis of 23 December regulation, and some other case who has been granted increase on the basis of the same 23 regulation. Yes. And if that we find no. So therefore, please better take instructions from your. Please better take instructions from your client.
I will I have no problem.
Yeah. Otherwise, if you find it to be incorrect, each petition will be dismissed with cost of 1 crore rupee. These are all business.
I'm saying something else.
So would you not find it appropriate to take instructions before making a submission? You are putting your clients at the risk of 3 crores. If you want to take that risk without asking them.
And if your lordship take the file of.
You take us only to 49. You point out to us one instance
49 are three matters. In one of the matter, one document has been annexed where my lord it is indicated that those who got in previous year, next year increase have been granted. I'm just showing.
No, but they might have a recognition under the
Sir, even under the earlier law, recognition can't be possible before if you have started in the previous year, you have to wait for 3 years. But if I start
Yes.
it will be completed in 3 years. The earlier regulation, as per earlier regulation, the recognition can only be after 3 years. Now, if I've got ballot addition in either 21-22 batch or 22-23 batch, I have to wait for respective 3 years to get recognition, right, ballot? But if I can demonstrate.
If somebody has got a recognition under the old regulation and he has been granted increase in it, that will be on different footing. Yeah.
If your lordship may kindly see page 239 of the SLP, my lord, SLP 70, my lord, number, my lord, it's a diary number 9749 of 25. What is the item number today? The second matter in item 49. Kindly come to page 239.
Yes.
Your lordship got it, page 239. There is a list, my lord.
So this is by Government of West Bengal.
No, sir, kindly come to, my lord, item number 13.
Item number 30 is publication of allotment result of online.
It's a kind of a list for this kind of. If your lordship may take this, my lord. I'm sorry, my lord, let me give your lordship the correct page number. This is diary number 9749.
Yes, we have 9749 only.
Take any other matter where this list is there. It is there in three matters. Please take the other five. In this work, for the item number 13, and then medical college, these seats are permitted in the year 22-23, and increase has been allowed before 22-23 would be 25-26 years.
कौन सा है?
Kindly see number item number 13. SN Medical College, Agra. Lordship got it for microbiology increased intake 3 to 7. LOP, that is the first 3 seats are permitted. 3 seats are permitted in 22-23. In 3 years will take place only 25-26. And your lordship, if your lordship asks for an affidavit from the other side, then how many colleges you are permitted? Without waiting for 3-year recognition, but your lordship will be inundated with a huge affidavit. And that is why they are not.
Okay, we'll call upon them. We'll call upon them to file an affidavit. But so therefore we are asking you. Yeah, and if from their affidavit we find that none of the institutions has been granted increase as per the 23 regulations, but as per the 2000 regulations, as 1 minute, Mr. 2000 regulations as modified in 2018, then we'll dismiss your petitions with cost of 1 crore rupees.
The person concerned and your lordship may permit me for tomorrow.
No, not tomorrow. Not tomorrow, because we don't want to waste our valuable time on this. You better ask your client whether does he have any case where is regulation, where is. We will ask them to file an affidavit, and if the affidavit, if we find that the statement is incorrect, we have to stop some such litigation at some point of time. So therefore, you better ask your client before calling upon them to file an affidavit.
All decisions are always put on the website which have stopped for
Okay.
last many years.
Are you willing to make that statement?
They don't have those documents, they only have this information.
If you are willing to make a statement, we'll.
My lord, I can't.
Yes.
Therefore, my lord, they are here and therefore I ask, my lord, if your
Are you willing to make a statement on instructions that you have been discriminated in as much as some persons have been granted increase on the basis of 23 December regulations, and you have been denied that?
Yes.
You are willing to make a such statement?
This annexure, I think, has been put on affidavit. I'm just checking up that. This very annexure.
Your client is present in the court, you can ask them. Somebody is there to instruct you.
They have only learned about this day.
So are you willing to make that statement? Yes or no?
It has been, my lord,
Dismissed.
my lord, I only, my lord, your lordship may not grant any relief, but your lordship may just keep that in mind, my lord. This is happening, my lord,
If you are so serious, we'll record your statement and we are making it clear that we will take them to task. But at the same time, if you find your statement is incorrect, we'll put you to cost of 3 crores. No, not a day's time. Well, Mr. Manindra Kumar, when you are coming with a case of discrimination, you should come with a specific stand. Not an allegation in the air.
Filed urgently because of the increase in the admission dates. But because the announcement of date, nobody was aware.
So it will cost 25 rupees, 10 lakh each.
Your lordship may not inform that, my lord, because your lordship may kindly.
These are all business.
I'm telling your lordship, my lord, that there are cases where they have granted, I don't have that document.
Please don't make any statement in the air. If you want to make, we'll put it on record. No. If you want, you make a statement at 2 o'clock, but with a rider. We'll make clear in the order that if the statement is found to be incorrect, we'll impose cost of 1 lakh rupees. 1 crore. We'll keep it at 2 o'clock.
And you may make a submission, but let them consider me now for the next year.
That they will consider if in accordance with law.
He has said shit. The council has already made a statement.
Then they will be issuing a public advertisement.
There will be an advertisement, you respond, and then accordingly they'll consider.
The inhabitability will come again.
Mr. Singh, a sentence more and 10 lakhs per minute. 10 lakhs per sentence. We have to respect your. We have to respect your status. Yes.
Whether there is any substance, maybe we are able to get document or not. Or your lordship in any given case consider why this practice of not putting the order.
The Medical Council of India, also Medical Council of India, has received the highest compliments from me when I was at Nagpur and Bombay.
Your lordship has said, but your lordship may just keep one thing in mind. All decisions are put on the website. There are.
Unfortunately, they were not interfered with by the Supreme Court.
I'm aware of it, but what I'm saying is, my lord, these decisions, why should they not be put on website?
And Malas, that's 60 lakhs now.
50.
Next matter. Allowed to withdraw, yes.
Both the matter.
Yes.
Great.
Steve. Been for High Court of Gujarat and High Court of Karnataka. High Courts. Actually,
no, we should have waited for the outcome of our.
Yes, I'm pointing out. Actually, all these High Courts, including Karnataka High Court, in terms of that Malik Mazhar case, they started the process. Now, since the judgment is resolved, we have kept everything in abeyance. We will kindly record our statement. Even Karnataka also issued a notification. Karnataka High Court also issued a notification pointing out that. So till the
Sri Natarajan, the learned ASG, appearing on behalf of the High Court of Gujarat
and Karnataka
and the High Court of Karnataka states that both the High Courts have kept the selection process, which was.
Karnataka High Court has issued. Gujarat, it was stayed. Now, while I'm giving an undertaking, we are not proceeding.
Karnataka also will not proceed.
Yeah, we should notification.
appears for the High Court of Gujarat and High Court of Karnataka. For example, the learned AG submits that insofar as the High Court of Karnataka is concerned, the High Court of Karnataka has already put the selection process in abeyance in order to await the decision of this court with regard to providing minimum number of years as a minimum number of practice as a lawyer as a precondition for appearing for the examination of civil judge unit division. He further states that insofar as High Court of Gujarat is concerned, since the procedure is stated by this court, a notification in that regard would be issued by the High Court. Is already issued.
Yes,
Yeah, a similar notification is already issued. But in that view of the matter, nothing remains for consideration in the present eye. The eyes are disposed of.
Please. That original petition which was pending before the Gujarat High Court, even that has been now withdrawn. That was the, but for that.
No, that was something different. A college which is not recognized the something which only Gujarat High Court can do. The college.
Thank you. Because this Milord's concerns Milord, I'm for the appellant. But she's granted leave, Milord. Concerns Milord the succession Milord and the estate of the erstwhile Milord, princely state of Kapurthana. As your lordship will just have the impugned order, just one or two things I want to indicate.
How much time you are likely to take?
It will take some time because there are three judgments during the pendency of the matter. There are three judgments of this honorable court on the, what is one of the primary issues is this according to us, that whether the law or the rule of primogeniture Milord survives after these Milord erstwhile rulers entered into covenants with the Union of India Milord, at that time in 1947 or 1948. Now Milord, according to us, in two judgments your lordships have held that the rule of primogeniture ceases to exist. Another judgment, Milord, takes a slightly different view. I will offer two judgments, Milord, takes a slightly different view that primogeniture has distinguished the earlier judgment and said no, that applies to certain different facts of the case. That's one of the core contentions of mine is Milord, because a lot turns on whether Milord, if primogeniture continues or not, then how the succession will flow accordingly. That's one of the primary issue as far as we are concerned.
So is it likely to be concluded today?
No, it will take some. In fact, we were thinking it will come on a Thursday, Milord.
But I have been handling this matter for the last 45 years in the High Court.
On both the sides.
Only thing is, now, after they argued the matter, after the matter has, evidence was concluded, I carried out the cross-examination on 16th August 1985. It was just delay and nothing. Now when the matter comes up, concurrent finding of fact decision by the High Court, they filed this SLP making a false statement and for saying consciously that the law was operative in Kapurthala state and therefore on that basis the request were able to persuade this court to grant admission. And that was a knowingly false statement and that law was not applicable. I succeeded prior to 56. In 1955, I'm a former brigadier in the Indian Army and the General Hindu law changed in 56 and for Punjab this particular act which they made a false statement on affidavit in Supreme Court was extended in 1958. I've already filed the notification. So I would only request let the Lordship may take up this matter whether the SLP should be revoked on the ground.
There is no application to that effect. After 14 years, my friend is saying, Lord, that there is some statement was made. Your Lordship's granted leave in 2011. There was no attempt made all these years.
Mr. Mittal could not have taken in a position for last 2011 to
yes. So
at least 24.
We could now say when the matter is ripe for final hearing that leave should be revoked.
No, my client.
File an application to that.
If my friend
They should have an application.
let him file, I'll respond to it.
Sir.
You file an application as to why the leave should be revoked,
Very well.
so that they can respond to that.
I'll do that.
Otherwise,
one sentence is all that.
well, the notice is issued in 2011.
Yes,
We granted 2011, my lord. Status quo order also subsequently made absolute in December 2011. They were heard because there's no question of the status quo order passed behind their back. Now, after 14 years, my friend says there is some revocation of leave.
Within how much time will file an application?
I'll file this tomorrow.
Within 1 day.
Yes, it's ready.
Okay.
The notification is there, the false statement is there, affidavit.
We know that issue arises, but let my friend file the application, I can then respond to it.
Very well, your Lordship may have it day after or whenever.
Actually, Mr.
My client is 91 and they just want to drag it till it
No, there is no dragging. Let me just make one thing. I'm very sorry to say this. My friend has raked this up, my lord.
I see it's all responsibility.
Can I just show the cause title for 1 minute and let us see who this fight is between? It is only between father and son. The wife, my lord, passed away in December. It's only the LRs today. I don't know what my friend wants. They have had, the father and son have met. They have had very warm, cordial exchanges, my lords, in the last 2 months. But my friend says, no, I am dragging the matter.
Well, why do you, we'll refer it to mediation then if it is.
No, that is the most eminent suggestion, my lord. The most eminent suggestion, my lord, parties should say, this is not a matter for your lordship to be troubled with you.
It's a family matter.
It's absolutely a family matter. Father and son, 2 sisters, one son predeceased.
How old is the father?
I will respond.
How old is the father?
90 or 90.
90.
And what is your age?
60 plus, 60 plus.
So only surviving son?
Yes. Only surviving and 2 sisters. Appellant number 4 and respondent 2.
At this age, is it not appropriate that it should
absolutely, my lords, I am absolutely, my lords, support.
I respectfully submit.
They don't want the settlement.
Right from 1985, whenever the matter was coming up for final arguments and the learned judges, whether on the trial side or on the first appellate side, expressed an opinion. Mediation, we family matter, we want to settle. So I would request that before.
We didn't express any opinion today.
Sorry?
There was no opinion expressed by us. It is at the outset we had said so. No, that's right.
Passage of time, my lords, relationships healed, my lord, that's what has happened.
Your Lordship has just hear me.
At the age of 91, do you have any children?
Yes, my lord.
Why deprive
He has
you?
met the grandson.
Why deprive yourself of the love and affection of your grandchildren?
Yes, we not have respect for.
I cannot settle the matters.
So more the reason that we request it for mediation here. You are appearing for whom?
I'm appearing for the respondent number 1, which Mr. Arun.
No, we don't permit 2 concepts that are about. That choice you have to make. Yeah. And we can't make any exception here.
My respectful submission is, especially a person who has been through wars, 2 wars fighting in front, want to at least have a finish this matter according to law.
You want to continue with the war?
Or continue or die on the battlefield. Or die on
Not a battlefield.
No, son.
Please.
Mr. Rao, you are appearing for the sisters.
1 sister. I am appealing for the son and the other sister. The supporting respondent. There's a. This is all talking about which our ancestors really got back. I was there to apply and I'm taught in Masters of Indian that I served.
This was a succession that opened
Mr. Mittal.
Yes.
Sorry. Is it not appropriate to give an end to all these things?
Okay.
Give and try because let the family be united.
Yes.
in your last years, rather than, living in isolation, live with your daughter, son, grandchildren. Ultimately, after you, everything is likely to go to them only.
I have given everything to the defense who survived me in the war. I've already made that application to the court. That they were my colleagues in the army who saved me from Pakistani bullets. And it is their community that gets what I have rather than the family who just troubled me non-stop for 48 years. 45
I didn't want to say that. I got photographs. They have met 2 months ago. Very warmly, very cordial. Please show. This is as recent as January of this year.
31st and 1st of April.
You can request Mr. Patolia to mediate. तो उनको बता दीजिए फोटो. Is he your client?
Yes, yes. I don't see it from there. Why this dreadful submission?
He invited them to his.
What I submit for this
No,
honorable.
Mr. Mohan, is the person in this photographs your client?
Yes.
Why do you want to unnecessarily? At times, it is the lawyers who don't permit the matters to be settled.
It's a final principle where 45 years of harassment has to be ultimately, like Lordship case.
And you appeared when the notice was issued. You appeared when the leave was granted and when the stay was confirmed.
Yes.
It is Mr. Mohan who has
Yes, I appeared.
to come up in the regular books for hearing.
Right.
You say you want the matter to.
No, my lord. But I would can I request that the matter can be heard and decided.
No, we'll decide it after 10 years. Unless you want to try for mediation.
Grateful.
It was यही कर रहा है.
Past list बनाई हुई है. पहला यही है ना, ये वाला.
An IA 105962 filed by the then president, who had asked to cease and desist, then contempt 340, everything was closed. Your lordship had asked me to give a copy to the amicus, but somehow it doesn't get listed. Today also we thought it is going to come up. It's not in the list, my lord. Could your lordship make some order that it be listed? I've handed over a copy.
My lord, I've seen the copy and I've also ready with my note, my lord, whatever your lordship desired.
Because in item.
One second.
Just one second. Your lordship may kindly let this be listed next time the matter comes up, my lord, so that your lordship.
I know, my lord, otherwise what I have suggested, my lord,
IA number is 105962. IA number 105962 of 2018.
962.
Yes, of 2018.
We have requested for expanding some remarks, my lord, because 340 and contempt, your lordship said accepted that discharge. So is a night of that also, if the lordship consider, my lord, those remarks, my lord, your lordship can consider to be fine. I have made that, if the lordship want me to hand over now, I will hand over. Otherwise, if the lordships are willing to take it, this application later.
Yeah, because it is better that it is on board. Yeah.
Do we have differences about this prosecution?
The prosecution has to be finally approved by the BCCI.
Some other IA, I interrupted off. Some other IA.
You are on some other eye.
Something else is going on, mine is a separate. I interrupted a lot.
Just finish this.
Just finish that, I'm sorry.
Yeah, IA number 105962 of 2180. Shri Patwali as a learned senior counsel, appearing on behalf of the applicant submit that though this court had directed the said IA to be specifically listed along with the present matter, same is not listed. Post the IA. Next week. Or next Tuesday.
Great. Completely mother file that more than file.
22.1 is before that, 22.1. 22.1, I have a suggestion.
What is 22.1?
Yes, it's an SLP 199679. SLP 199679, J&K. Despite all our criticism and differences, your lordship's object is to have elections. Let the elections be held as per the new constitution. So that solves it. -1 problem is. Please stay and keep in abeyance clause 10, by which they are suggesting that there should be registration of every club. The reason all of us are objecting, or many of us are objecting to clause 10, which is the only thing, in abeyance of which the election at least can be done, is because it is not recommended by the Lodha committee, it is not recommended by the Supreme Court, and it affects the right holders of local clubs to play. That's about it, to associate.
Where is that clause 10?
Yes,
clause 10 is we are at variance. We are not at variance, therefore I am just cutting my learned venture.
I am just taking 1 minute as a mind customer. They are right, they have applied to the registrar for registration. He has asked for a document of approval from the BCCI. So, I agree that
we have approved
that minor that condition for the time being.
For the time being, correct.
But what can be done, Lord, I think I respect.
Ignore the rest. Ignore the rest, just see the first.
Lord, the constitution as approved by the BCCI and as seen by the learned amicus can be treated as a constitution. Number 2, the registration formality can continue, but right now it should be treated as registered. The election should be held, and election should be held by a person whom the learned amicus can assign. Just a non-neutral independent person. I have no difficulty.
Election, any person who has retired from the Election Commission of India, one of them is always one of the Washington preferred them for conducting the election.
There is no clause 10 in this.
First page quotation. On the first, just for quotation purposes. No club or para 3 under that. No club or association shall be affiliated or its affiliation continued unless it is registered as a society or as a not-for-profit association which has submitted duly audited financial statement.
What are you doing?
The clubs.
I think it is short note, not the constitution.
I don't have the note.
No, we gave a note to you just now.
Which one?
There is Mahendra Singh and Mr. Tushar Mehta that your lordships can treat it as for the time being registered. That's all there is to it. And let the elections be taken.
We see from that.
Exactly what I said, Manoj.
That's what I'm saying. There is I'm saying there is
Yes.
But then which will be the list? On the basis of which list the elections will be held?
Page 30, please see the IA that I've just given to your lordships.
No, that's one submission. There is a constitution which has been prepared by the subcommittee appointed by the BCCI, which it appears, I don't have the document, has been approved by the BCCI.
It is.
I am not seeing this note, detailed note, what this note. One submission. If there is any problem on that registration, whatever is already submitted, then we would require to see this note.
Yes.
I don't want this note to be taken as a part of your lordship's order and tomorrow I am told that you would have a conflict.
I don't have even note.
We will have it on next Tuesday.
Yes, you gave a quotation of 10. The note you are discard.
Yeah, I could
discard.
I'm not saying we can have it tomorrow and just let the public to be read.
So the solution may not lead to another problem.
Therefore, we are asking, if that is to be ignored, then there has to be some list on the basis of which elections are to be held.
We are at one page like that.
Possibly, my lord, I have not seen what clause 10, possibly, I have not seen the note, possibly clause 10 is for a different purpose. It says that irrespective of registration, it should be treated as registered. But let us look into it.
Okay, well, your lordship may do one thing. ignore the note, see from the file.
Let them go through the note.
The note has other submissions, I don't want to go into the submissions. I can withdraw the note, see the clause at page 37.
Constitution.
Let us go by the note, but let us go by the SLP. Give me just 2 minutes. The additional affidavit in 19979, you have copied that. 2 minutes, only 2 minutes. There is an additional affidavit in 19979, which page 37 has got the clauses proposed by the BCCI. I'll just take 2 minutes first. By the clock. First. The additional, kindly, madam, hand over.
Exactly this.
Yes, it is additional affidavit. Justice Masi, I think, has it. Justice GAVAI may not have it. I don't know. He's got it. Turn to 37. Now the clause is at 37. It starts at 36. Grounds for sanction and derecognition. And I'm all agreeing with them. I'm not arguing. I'm agreeing. I'm saying there is a rare unanimity for this limited purpose. Then 37 is no club or association shall be affiliated or its affiliation continued unless it is registered as a society as not for profit, etc., etc., for which has submitted
So this can't be, there was a scam unearthed based on this clause. This is the heart and soul of the The audit matter was opened because of this clause.
Now, the reason we said that this, for the time being, the elections we held.
What are the learned amicus to say about it?
So let us go through it.
Yes.
As per your lordship's order, the matter went to.
So because unless this clause is found to be untenable, why should we interfere with it? Because it says that no club or affiliation should be affiliated with affiliation continue unless it is registered as a society or as a non-profit. Otherwise, any Tom, Dick, and Harry may say that I am a member of.
Financial statements. That's what he is objecting to. Because there are scams and the audit, etc. is pending.
But even for future cases, your lordship are considering, I only want to remind your lordship of one respectful submission that the procedure adopted is that whatever constitution is prepared, as per your lordship's order, it go to BCCI.
From there it will come to you.
Come to me now in this manner, BCCI appointed a subcommittee. Subcommittee are given that constitution to them and then apply for registration. These objections are when the registration is pending. I have no problem. BCCI look into these objections and give your response to your lordship.
But this constitution has been approved after it is vetted by you.
This clause is coming for the. What my message?
It is coming in the, but then that subcommittee when it finalized the constitution.
BCCI has finalized.
It has come to me 4 days and that.
He wants an exemption from this provision, which is according to me.
I have no problem with that.
But why should you have no problem? Because this appears to be a valid clause. They are opposing it. So, you are giving an impression that you are also agreeing for his non-opposition.
Can I say why I am opposing? One sentence why I am opposing. Your lordship rightly asked, why should this clause not be there? This has come for the first time to us, to him also, to me also. Para 64 and 65 of the main judgment of BCCI 2016-8 SCC 535 has detailed para saying the right to associate in whatever form for the game of cricket should not be inhibited. We are saying this clause is A, not mandated by the Lodha committee, B, not mandated by the BCCI.
Is it in conflict with the recommendation of the Lodha committee?
Yes, that's it. I'm grateful. According to us, yes.
How can? No, if there is some mechanism which provides that there has to be regulation insofar as membership is concerned, how can that be wrong?
Please give the judgment. Please take to para 64.
The Lodha committee does not say auditing is a must. That's what the.
No, auditing is not a problem. Nobody is opposing auditing. All that I have to say is read 64 and 65.
That's the general observation. The right to form an association.
Can I read your lordship?
Cannot be denied.
Mr. Mehta, page 590 of the SCC. Page 590 of the SCC. That's all that I am saying. And the election should not be held up for this in the abeyance period is the second point. There is, I really want to read 65, but your lordship permit to read both 64 and 65 very quickly. That's what she has got it.
Yes, sir.
There is, in the light of the above authoritative pronouncements, no room for any doubt. There is a right guaranteed under C, or if you mark C, cannot be claimed by an association or union or cooperative as it is sought to be done in the case in hand. Even if the right to form an association or union or cooperative society extends to the continued existence of such association or union or cooperative society with its original voluntary composition. But the right does not extend so far as to include the right of any such association or union or cooperative society to achieve its objects or to conduct its business unhindered by any regulatory or other control. Anything beyond the protection of the original composition of the association or union or cooperative society would fall outside C and shall be governed by other clauses of 19. For instance, the right of the association or union or cooperative society to conduct its business or pursue its object shall be regulated under 19(1)(g), read with 6. So also the right to move freely throughout the territory shall be governed by D, read with 5. Suffice it to say that so long as the initial voluntary composition, this is the whole idea, of the state cricket associations which are complaining of the breach of the right remains unaffected, there is no violation of what is guaranteed by C. Next paragraph.
No violation, but where does it mandate that there has been no registration?
Can I, only a minute, Dr. Singh, only a minute.
Allow me to one more paragraph, please just be patient for 1 minute. Now, seen in the backdrop of the above, the recommendations made by the committee in the instant do not interfere with or alter the composition of the state associations. Individual citizens who come together to form the state associations have not been asked to discontinue their association, nor do the recommendations impose upon their members or obligation to associate. Now this condition will. This condition will hinder.
Impose upon their members an obligation to associate with others with whom they do not wish to associate.
No, therefore.
So what is the requirement? What is the requirement under B? Is suppose if 10 members want to associate with themselves, they shall follow the procedure of registration with the registrar.
Found to be cancer, he can be removed and
Allow me to finish, please. Well, unregistered as an inhibition or prohibition is not contemplated. What my lord is saying, they are.
We don't agree with that. We don't agree anything wrong with the clause.
Because that's an added condition.
Maybe one can always improve. Is it in conflict with the directions of the Lord of the
filter or additional fetter on the right to associate?
It's always permissible.
No other state constitution has this. No other state constitution. This
Would your lordship honestly say they take the additional affidavit filed by them, additional affidavit which is filed by them. It is just to identify Soeb Qureshi. In youth cricket club.
Yes.
Please have a look, But they were found, there are 2 clubs. Page 7, your lordship has page 7. Page 7. This is a document prepared by them. This is the objection, and this is why my learned friend said that 10 be suspended. Clause 10 of the Constitution. Note, your lordship gets from it. The voting rights, does your lordship have? Page 7, my lord. Just left hand side column. Left hand side column. No, the voting powers of Amateur Cricket Club Kashmir and United Cricket Club Kashmir will be kept in suspension till the case of JKCA scam is settled. FIR lodged at so and so, dated so and so, CBA case so and so, it is so and so, as unanimously resolved in Jammu Kashmir Cricket Association Working Committee. So, the decision is taken by a democratic body in 2015 that these 2 people are guilty of impersonating, forging signatures, financial scams, etc. So, their voting right is suspended. But come out of this, he is saying that 10 be exempt.
They've been kicked out. They have nothing to do with this club. The club can't be penalized.
We, prima facie, don't find anything wrong in that condition.
May I say one thing? JKCA is
putting an association to some regulatory mechanism. What is wrong in that?
First of all, this is
tomorrow any Tom, Dick and Harry will say that 3 of us have formed an association. Give us a voting right.
Have they, please ask BCCI in the whole country, do they have for any other than J&K association the requirement to register? Let me say for all. I have no problem. Why are they singling out J&K? Number 2, to prejudice your lordships, 2 people who are facing individual charges of criminality, chucked out of our system long ago and not part of our system for a long time, have been brought in back to this clause. We are not with them at all. They left long ago.
You point out to us as to what is palpably wrong with clause 10B.
2 things that I have nothing more to say. 1, It's an additional inhibition by way of an ultra-vires addition, not contemplated by Loda committee or 64-65. I agree, although I bow down that there is no para in your lordship's order saying there shall be no registration requirement. I agree. But the implied addition by this constitution, by this BCCI. Number two, BCCI is a body for the whole country. They cannot stipulate 10 for J&K alone. Let it be for all, no problem. Number three, this is not a fair link for lordship or prejudice. This is something about a scam where 2 or 3 people are criminally charged, they are out, they have nothing to do with us. That's the 3 points.
If you are agreeable for election with this constitution, we will direct you.
On the election, as per their list of voters, now I asked who was list, that is at 30, as per them, page 30, same documents.
No, which list?
Page 30 of the same, given by you. Given by you.
Page 30.
Page 30 is your list.
No, this is part of the constitution, given by them, and in fact, there is a caveat on 31. Please see, those two clubs.
I'm sorry, they don't mislead the court. These 2 clubs are shown as members without voting rights. Don't do this. Please don't do this.
Now, finish my kindly see, there is a caveat saying that they won't vote. We have no problem to that. Keep them out. Keep them out.
With a note.
These
With a note.
Absolutely.
Note on page 30.
No, he is agreeing to that note also.
30 and 31 laws is very clear, and that list, let us go ahead with that clause. Whole idea is, 7 years they have not had elections, they have suspended the body too. And once after a lot of push from your lordships, this constitution is for the first time seeing the light of the day. Now, the list is there, we want elections to happen, the elected body will come.
Okay, according to that list only.
So who should be the election officers?
That's not
Mr. MI can suggest.
Generally, your lordships have appointed a former election commissioner of India. But we can find out, otherwise I have been informed there is one former election commissioner, Mr. K.K. Sharma is from Jammu. He was the...
Just find out and tell us on next Tuesday. Have you asked whether Justice Ravide is available? Everybody is sustaining work on him. No, explain, but then he should also have some time for his other work. Otherwise, if he does it. Otherwise, everything if he does is pro bono. Some committee is asking him, some court is asking him to conduct the elections of the Supreme Court Bar Association. Then frame the.
A former judge of this court can't be conducting elections.
No, one can understand.
Justice Nageshwara can have. We have no objection. Just
no, we are only saying there should be some limit of the work which we thrust on him. Yeah.
Merely because he is good,
that can work to his prejudice. Next Tuesday.
Please.
22.2 Milos. This is a writ by Uttaranchal Cricket Association. Your lordships had appointed in 2017 a committee of administrators, which Milos in turn appointed a committee of affiliation. So Milos committee of affiliation had given a report in our favor. There were 4 competing Milos associations who wanted to be affiliated. And Milos, that report which was after ground inspections, everything. That report was set aside by the committee of administrators, which we had challenged here. In the meanwhile, your lordships, the learned amicus, we were asked to give the copy of this to learned amicus, and learned amicus Milos was asked to give a report on this. So Milos, there is no written order, Milos, while it was pending before Honorable Justice Chandrachud. We were asked, because learned amicus was seized of various similar issues, Milos, which he was looking into. Milos, we can make a request. If Milos, if the written order is not there.
I've seen the paper. This is a petition now being taken up for the first time. Your lordship may resolve this also. But it seems there are 2 players who take this Singh and Mr.
So that.
They gave a report, my lord, which did not use the word that we are recommending affiliation to this association, but they gave all good features for this association. The matter went to Committee of Administrators to the BCCI. I just want to read 2-3 paragraphs of that, which doesn't seem to be in 9 and doesn't seem to be in sync what the recommendation was made. So I can file a note or I can show you.
File a note.
I can file. Within 2 days I can file it or what also I will be from next week.
Because in the meanwhile, maybe request for the notice to be issued in this case. In this writ.
What are the contesting parties?
Because the contesting parties is BCCI and
Because there is another association who finds favor with the board of administration, not with the affiliation committee.
Then this will have to be at a longer time. Then.
there are two other associations.
Then you'll also may have it after 2-3 weeks, but I file a note within a week.
Okay, issue notice.
Okay.
Retail about 4 weeks. Justly permitted.
Will it be said?
Because
My concern.
I mean, you don't have to.
please do not, we understand. We understand.
I'm saying even now I can show the bill.
Yes.
I apologize also.
Always ready with the matter.
Because we understand, it needn't come.
Plot item 22, 13 in the list, plot. Is an I filed by the Mumbai Cricket Association. Plot, there are certain amendments that we are seeking. Plot, what happened was that earlier we are meeting with the earlier amicus. Plot, some issues were resolved, some were not. But unfortunately, while giving the report, there was some miscommunication, and plot, we were put in the category of all issues being resolved, which we sent email, etc. But plot, that was not changed. Plot, we have filed an I. I have prepared a note what working difficulties we are going to have.
Why don't you discuss with the learned amicus?
Yes, Lord, I don't mind. And Lord, it's not in conflict with the BCCI constitution. It's only the day-to-day working of the association that is going to. I can share that note with my learned friend, the amicus. Lord, my Lord can have it after 3 weeks, Lord, whatever convenient, Lord, I can point out to him the difficulties.
You can sit through with him. You invite him to Bombay.
Yes, Lord. My pleasure.
I'll get the copy, but what I will instructed now, Mr. Kota is doing the matter from the beginning. So he informed me perhaps a view was taken that whatever is sent to mediation and it is resolved, whatever remained unresolved, that was needs to be decided and not.
That's right. But unfortunately,
Taken a view and there is an order. We can place it after.
Let us see that we file a.
We will sit with the amicus.
File my vote, watchman, give us some time. I'll file.
Then we'll give another copy. There's no difficulty on that score.
उसको भी 4 week के बाद करो.
I number is 41508 of 21. Okay.
I appear for petition.
He, Mr. Kota, from the beginning and he was asked to continue with me also when I get. His name can be continued with the orders because then he.
I was an AO earlier,
We direct the registry in the appearances of Sri Putaraju, the learned senior counsel, along with Sri Anindra as amicus query. Is there anybody to assist you now after you become an senior? There's always been there.
I appear the petitioner in the matter at serial number 23.1 and 23.2.
I appear in the main matter, that is 23. Here, the issue is that.
Yes.
Here, the issue is that the writ petition was filed by the petitioner before last year, pointing out that in 1993, IDBI had come out with the pension regulations, which were changed in 2012, which were challenged by way of a writ. In that writ petition, the theme was taken that IDBI is not a state and therefore writ petition is not maintained. And the High Court has heard that plea flood and has held that IDBI notice taking. And that is the issue before your lordship. Lord,
This request to be heard at length.
One more, they also may take note of a recent Supreme Court judgment.
Lord,
It says that by the time the writ petition is heard, if it has been privatized, then the writ cannot be maintained.
That Air India.
And that is a number of his judgments also.
That does not affect me at all. So that is one of the issue, of course, in my petition also. But he owes that issue also.
Well, I think Air India was also the judgment of the same bench from Bombay.
Yes.
In fact, in this judgment, there is a reference that few minutes before we have decided that Muddy Reddy judgment, which was Air India. But there is a difference between.
But that view has been upheld by this court.
Yes, but there is a difference between Muddy Reddy judgment, that is Air India, and this matter. In case of Air India, the conversion will not.
Do you have a copy of that judgment?
I have a comparison taken.
No, apart from Muddy Reddy, other judgments also have taken the same. There are judges extracted in Para 72. I don't, so Lordship is hearing it, then I.
Lord, in Madi Reddy, Lordships have decided to let two issues. One,
it is on page 164 of the compilation is the judgment which was given by my Lord Justice GAVAI and Justice Mayer. Page 164 and page 280, Lord, is the judgment given by the division bench of Bombay, which is the same division bench which has given judgment in IDBI. But there is a difference between that matter and this matter.
Please see para 22 of the Lordship's judgment, Millard, wherein Millard, the Lordship had formulated Millard two questions.
One 164 melody.
It begins here, yes.
The question of law presented for adjudication of this court are whether the respondent number 1 Air India Limited and number 3, after having been taken over by a private corporate entity, would have been subjected to jurisdiction of the High Court. Whether the appellant herein could have been non-suited on account of the fact that during pendency of their writ petition, the nature of employer changed from a government entity to a private entity. Now, this question number 3, whether delay in disposal of the writ petition would be treated as a valid ground to sustain claim.
Because of the observations made by the High Court to that period. Because of the observations made by the High Court, they tendered an apology for the delay in.
The Chief Justice said that on behalf of the
High Court,
we are tendering the apology because we could not dispose of the matter. But my Lord, may I say one thing? There are only two submissions which I want to make. Then your Lordship may fix the time. Two submissions which I, three submissions I make. The first submission that I want to make, my Lord, is that the judgment in Air India differs, my Lord, from the matter, my Lord, in your Lordship's time. For the reason that in case of Air India, Air India initially started, my Lord, as a statutory corporation. Then it became government company. At the time when the writ petition was filed, it was a government company. By the time the matter came for final hearing, from government company, it became a private limited company. Now, because it was a private limited company, my Lord, the High Court came to the conclusion that it is obviously not state, and therefore, my Lord, decided this matter. In case of IDBI, even on the date when the writ petition was finally disposed of, even that time also, 94% of the share capital was held by the Government of India and, my Lord, the LIC. Now, LIC, your Lordship knows in Sukhdev judgment given by your Lordship's court, this court, my Lord, has held in Sukhdev's matter that LIC is a state. Now, even on the date when this writ petition was finally disposed of, if 95%, 94 point odd, almost 95% share capital was held by Government of India and LIC, number one. Number two, out of, my Lord, the number of the director, almost all the directors are appointed by the LIC only. And therefore, I am saying that if you lift the corporate well, you only find 2% behind that, namely the LIC and the Government of India. That was not the case of Air India. Air India, it was Talase private limited company, individuals. That is number one. That therefore, that case differed from this. Second submission which I want to make before your Lordship is that since the right of pension is involved here, I am relying upon a recent judgment to which my Lord Justice GAVAI was a party, Justice Nagaratna, my Lord, taking a different view. Where the issue was, my Lord, that was the judgment, my Lord, in Kaushal Kishore, where the issue was that some of the fundamental rights in part 3 are available against the state, like Milord Article 14, etc. Some of the rights are available against private entities also. A question arose that whether the fundamental rights contained in part 3 can be enforced also, Milord, in respect of
Don't worry, sir.
in respect of Article 19 and Article 21, whether the private entities or against them also it is enforceable. Your Lordship, Justice Milord Ram Subramanian J. Milord has authored that judgment. Your Lordship was the party to that. Your Lordships have taken the view that so far as Article 19 and Article 21 are concerned, they are also available against the private entities. In my respectful submission, the second point that is required to be considered is when somebody gives a knock, Milord, to your Lordship door and says that my fundamental right of pension is violated, forget, Milord, the pay, wages, etc. My fundamental right of pension is violated, and Article 21 DS Nakara would apply. And then in that second submission is, in the light of that judgment given in Kaushal Kishore, the second submission is that this entire discussion whether the respondent is a state or not state has become irrelevant, because even if the respondent is not state, when it comes to right of life under Article 21, in the light of your Lordship's judgment, a petition will be maintained. Is my second submission. Third submission, Milord, is that it is true, Milord, that at one stage this court, Milord, has taken the view, Milord, in Federal Bank, and your Lordship knows that, Milord, a banking company is not, Milord, a state within the meaning of Article 12. But thereafter, Milord, there have been number of amendments in the Banking Regulation Act, Reserve Bank of India. As a result of that today, what loan should be given, whom the loan should be given, how the loan should be given, everything is under so deep and pervasive control of the Government of India and the Reserve Bank of India that is required to be considered whether this particular bank, IDBI, which is 95% Milord is Government of India and LIC, is really a state within the meaning of Article 12 or not. These are the 3 points which are required to be addressed. And on these 3 points, in my respectful submission, the judgment which was given by your Lordship sitting with Justice Mehta, Milord, in the matter of Air India, does not apply here.
My friend, allow me, Milord, in the main matter. What we have pointed out, Milord, before the High Court and also before Lordship, that IDBI has come into existence as a direct shift of the Department of Government of India. The entire functions of the Government of India were entrusted to IDBI by way Act of the Parliament. That is in 1964. And I place before Lordship the statement of objection reasons to demonstrate that yes, it was the essential function which was being done by the government at that stage, which have been transferred to the corporation, thus created. Of India, with stipulation that these are the works which company will do, and the entire regulatory measure, the entire control over the functions of the IDBI vested with the Government of India. The entire board was created by the Government of India. Later on, the only change which the Government of India made was that instead of direct control of 51%, Government of India brought in LIC, and then LIC and Government of India together has led more than 95% share. 5% shares were only permitted to outsiders. So at the stage when the High Court decided this writ petition, the only distinction and the distinction with vis-a-vis Air India is that as on the date when the petition was decided, the total control, functional, administrative, as well as financial control was with the Government of India. Directly or through indirect mechanism, that is through LIC.
That is what Mr. Andurkar also said.
That's the only issue and which your Lordship has to determine. High Court has made a High Court has, instead of going functional control, has functions of the function test, namely the public function test, which High Court itself reported that I had specifically made a statement before the High Court that we are not pressing for public function test.
Sir, just see page 709 for 1 minute and read 2 lines only. Page 709.
Of this compilation?
Of that compilation. I'm sorry, it is little bulky. I could have divided it into two parts actually.
There is a convenience compilation filed by both the sides.
Page 709 is from the High Court judgment, impugned judgment. Page 709. Kindly see paragraph number 4.8, 4.5. Page 709, first paragraph. Please see last 3 lines. In the month of December 2020, my lord got it? In the month of December 2020, the respondent bank raised equity share capital of rupees 1435 crore through qualified institutional placement (QIU). Post completion of QIP issues, the shareholding of Government of India stands at 45% and that of LIC stands at 49% on 31/12/2020. So this shows that 94.72 mathematically exact is the shareholding of Government of India and the LIC. It is not like the Talase Private Limited in which Air India was converted into. There the transformation was to Talase Private Limited, which was a private limited company. This is Government of India and the LIC. And it has been held in Sukhdev. I have enclosed a copy of Sukhdev also in the compilation that LIC is a state. Now in a matter like this, if we want to lift the corporate wealth, then in which matter we would lift the corporate wealth? And these are admitted facts.
Yes, Mr. Dadar.
The learned judge has gone into administrative control, financial control, Pradeep Kumar Biswas, Som Regi. I can argue at length, there's no problem on that. Because IDBI, first of all, the learned judge also mentions this is one association. Out of 17 associations, only one association comes. 90% people have accepted the pension scheme also. There is a board resolution passed in 2008. I've got lots to say on facts. I'm ready with the madam.
How much, what is your estimate? How much time will it take?
I will take half an hour to 45 minutes.
I will also take you about an
What about you?
But my role is very limited, but I have to show unless the impugned judgment is found to be perverse or
that test would not be available. Huh? How would the test of perversity be available here? It's coming up for the first time after the High Court.
No. I'm just saying that the learned judge has followed Som Reki, Pradeep Kumar Biswas, all the line of cases, and learned judge bench has come to a conclusion. Unless that conclusion can be said to be not sustainable on the basis of those judgments.
No, but if on fact, if it is found that 95% of the shareholding is with the union and the LIC.
No, even that. No. There is also not admitted, not fully admitted. There is also a point, even if the shareholding is held, if they are not performing sovereign functions, they're not performing this, it doesn't mean it becomes the judgment of Biswas, Pradeep Kumar Biswas. Shareholding is one of the indicia. It is not the conclusive indicia. I am ready to add. Lots of control, maybe one afternoon.
whenever Lord.
So even if it's a 100% government-owned company, it doesn't become necessarily a state. It has to perform sovereign function, administrative. It has got an independent board of directors.
Have it somewhere in April.
Any day whenever Dr. Dean. Because Lord, initially Lordship had issued notice, Lord, and your Lordship will see the first order, Lordship had indicated that on the first date itself it will be.
But can we also do one thing, Lord?
We'll grant leave. We want to keep it on some Thursday. So that
Leave granted.
we have part on some Thursday. You have to finish by this Thursday, both sides.
That power.
Yeah.
Yes, we are finishing.
We better tell Mr.
I think tomorrow afternoon, Lordship is hearing the other side. Mr. Ramchandran and others.
No, tomorrow afternoon we have kept it for you.
Tomorrow afternoon is the turn for Mr.
Vaidyanathan also.
I think Mr. M. Ramchandran has started.
No, Mr. Vaidyanathan also wanted to first.
He wanted to add something.
He wanted to add something to you.
Tomorrow 2 o'clock, and then Lordship said day after we have to be finished. I think even by lunch also we may finish if the other side. But in this case, my only mention is that if the Lordship says that Madi Reddy is not applicable, then the Lordship has to go to the issue of state. In that Madi Reddy judgment, saying that if the company has become a private entity before that, if their contention is even that would apply because even now we are almost a government company. That's the point.
That distinguish in that.
Then I don't mean that. I can also do one thing, I can give a written note summarizing the proposition will be easy because this what is state, you should have heard hundreds of times. Article
and still not 100% desirable.
Yes. But 7 judges. Utpal Basu and all those things.
We'll have it on 23rd, preemptively.
Yes, deeply obvious.
Preemptively, high on board. Yes, I am voting.
Since the Russians got consent of time, give a synopsis of submissions.
Of course,
one year earlier.
Of course.
I'll also exchange. So by 15th April, if you can exchange submission,
that will be.
it will narrow.
And there's a common convenience compilation.
Common convenience compilation that is already filed.
So we request the constitutive the parties to exchange
Synopsis.
their synopses and the written submissions prior to 15th of April.
Page limit. Normal documents says 5 pages, 7 pages. I'm asking about it.
But make it within 10 pages.
10 pages. That's very good.
I had Dr. Singhvi here, then we would have requested him to do it in 1 or 2 pages.
They would do it there. State matter 23, Malad, is that West, 46 is that West Bengal matter.
Yeah.
The Lordships will remember that. Now, Malad, in this, what we have decided is that the commission is going to reconduct the entire exercise. So that a fresh exercise will be done as to we move backward what is to right. Now, therefore, my request is take it up, and that exercise will be over in 3 months' time. So you also may take it up after 3 months.
So you want it to be in July?
Yes, in July.
Nobody
Nobody can object. We don't have an.
They can't have an objection.
But they can't pitch it on the new study they are doing.
No.
That they have done now.
No, if the new because they are aggrieved by the decision of the National Commission as well as the High Court.
Yeah.
So if the entire exercise is being redone,
yes,
and after redoing that exercise, if the fresh reservation is provided for, and if nobody is agreed with that, then this question may become academic.
Correct. So therefore, have it in July.
But it's not be done. There was no exercise done.
Earlier, so. But if now, on the basis of exercise, they provide proper reservation and with that, if nobody has a grievance.
They come up with something like that. It's always open to parties not to challenge it afresh.
Discussing that, but there are questions of law that are decided in the High Court which are questionable. Therefore, I'm not having it both ways. I'm saying they'll come up after that exercise is done. I'm not seeking, there's no stay on it. We can't have an objection on that, so let it come up in July sometime.
Their requests.
Yes, of course it comes.
Mr. Sibal, the learned senior counsel, states that the State Backward Commission or the State Commission?
West Bengal Commission for Backward Classes has informed the government of West Bengal that they would conduct a benchmark survey on communities who have applied to the commission for inclusion in OBC list of West Bengal.
State that the West Bengal Commission for Backward Classes
yes,
is undertaking an exercise of examining the issue of backwardness afresh.
Yes.
Which will be further submitted the same is likely to take a period of 3 months. Post the matter in July.
After of course without prejudice to all this.
Yes. Solvent is without prejudice.
Needless to say
without
prejudice to the contention.
Needless to say that the said exercise. The said exercise will be without prejudice to
reach it again.
Yeah, without prejudice the rights of either of the parties in the present proceeding. At least we are served with one heavy matter.
I know.
For the time being.
So are we, Malad. So are we at this end.
We all move to the next court.
Right.
Manoj, kind permission, may I mention item number 44? Because this was the same matter which Khija had mentioned in the morning, whereby Manoj had asked us to try our luck after lunch. This matter may not reach today because it is effectively the last matter. Our request was that it could be on any other day higher up on the board. It is that contempt matter, Manoj, where my property is lying as a collateral. I've informed the other side, Manoj.
They cannot go pay what you table.
Manoj, if it could be higher up on the board, it's much obliged.
Your Lordship, I want to mention item number 33. Your Lordship, in this, your Lordships are pleased to issue a notice on 13th of December 2024. It's on item number 33 today, which is not likely to reach, but till date we've not received any counter from the respondents or the advocate who was appointed. So your Lordship, it's a humble request that they may be directed to file a counter and it can be listed on the next.
If they don't want to file, we can't compel them. You have been requested to act as an amicus, yeah. Next Tuesday.
Your Lordship, high on board. If there's an interim application, your Lordship.
Yes, sir.
Obliged.
Appear on behalf of the petitioners. But we have taken out this application. Let me tell you about the background.
Your Lordship, can item 33 be Wednesday? Senior is not available on Tuesday. I was just informed by the seniors.
So Singh is a Singh.
Wednesday.
Who is the senior?
Miss John.
We have already said that we are not going to, interfere with the order. We just want to, lay down something because that within such serious offences also the grounds of arrest could be. Anyway, then when do you want it?
Wednesday, 20th.
No, Wednesday is okay. Wednesday.
27th. Wednesday.
Lord, I appear on behalf of the petitioners. We have taken out this application, which is moved before your Lordship. Lord, let me tell my Lords the background. Lord, there were multi-purpose health workers who were appointed initially on contract basis for 11 months, but continued without break thereafter. And after about 7-8 years of service or even more, they were terminated. Ultimately, single judge, the Honorable Division Bench and your Lordships will not confirm the order in our favor. We are actually appointed in the post. That orders of regularization, etc. also are passed. After your Lordship dismissed the SLP, the review application was filed after almost 3 years. And that condonation of delay application was allowed, which was under challenge. Your Lordship passed an order issuing notice, and this see the order which is passed in this application, page 17. Lord, this was after hearing the respondents. The next solicitor had appeared on behalf of the state. Para 18 is the relevant part of the order. Your Lordships are seeing the application. I number 62741, page 17.
Yes.
So the relevant part of the order is at page 18. Permission to file SLP is granted. Issue notice on the application for interventions as well as special petitions returnable within 2 weeks. Ms. So and so appearing on behalf of the state for 1 to 5 accepts and waives notice. In the meantime, there shall be stay on the consequential effect of the improved order. Since delay condonation application was allowed, that actually stayed. So as a result, this order was passed. We see the date 10th of July 2023. So everybody understood this to be the stay of further proceedings. Another set of employees, some orders were passed on the same lines, which came to be challenged before Lordships in another SLP, which is the order passed in page 19. And that is not after almost about 1 year. 9th of August. Learned counsel appearing for the petitioner seeks permission to withdraw these petitions with liberty to file review before the High Court. In the event the petitioners do not succeed in the review petition, to approach this court again. Permission is granted. Special petitions are accordingly disposed of as withdrawn. We further clarified that the order passed by this court in dated short, so that is the order which I just shown, would not be considered as staying the review proceeding. This is the order passed in those petitions where review is permitted to be granted. State now urges that no, this review petition where your lordships will not entertain the petition and granted that order also has to be heard. And therefore, this is the order in which I am not party, we are not party. This can never be constituted to mean the vacation of the stay of the, and state or alone understood the order to mean the stay of the proceedings. And your lordships heard it for some time and then kept it for final disposal. That your lordship, but till then your review cannot be heard. Otherwise, since 2007 they are working. Regulation order is passed. They wake up the controversy after 3 years by filing review petition. And if the review is heard, the whole object of your lordship.
No, what are the challenge in the other proceedings?
Because similar kind of orders passed in some different set of employees. There are some factual differences in that. I am not concerned with that.
Yes, who is happening with the straight face?
I straight away answer what my learned friend is saying, but your lordships permit, can I have briefly note your lordships some context is important for your lordships to know why your lordships passed the order. There's two sets of petitions and cases started in the Gujarat activism. One pertaining to what were called ad hoc employees, and the other pertaining to contractual employees. The ad hoc employees, my lords, came in through a proper selection process. Their own letters of appointment said regularization, etc. And they, after 2 years, will be appointed. The other were contractual employees, which my learned friend represents, which are 11-1 walk-in interviews without any process added. These contractual employees, in repeated repetitions, asked for regularization, and repeated repetitions of identically situated people were dismissed by the Gujarat High Court. At the same time, the ad hoc employees also said that now you've regularized 17 of our other people, regularize us. The Gujarat High Court, by a detailed judgment there, and said, yes, these people are entitled to regularization because their appointment letters and terms and conditions of appointment all provided that they should be done, and just because you did not hold a selection to regularize them, they can't be faulted for that. In that, in fact, a parity was sought between contractual workers' reputation being dismissed and the ad hoc employees. The Gujarat High Court categorically rejected it, saying that the contractual employees, that is whom my learned friend represents, are completely different from ad hoc employees and recorded. Now, after that also, more repetitions again dismissed of the contractual employees. Then comes the order of which the review is pending. A Kalyan Samiti repetition comes to be filed, where the Gujarat High Court relies on this judgment of Jagani, which actually says that two are completely different, and relies on that judgment despite the earlier orders rejecting the piece of identically based contractual employees, relies on a judgment pertaining to ad hoc employees, and holds therein that in view of the ad hoc employee judgment, you are covered and thus it ought to be granted. Now, what happened therein was, my lords, no one ever pointed out to the court. To that extent, I said it on the first day itself, even in the other matter in this matter. That's why your lordships permitted me to go and pursue the review in the other matter also. That in that Jagani judgment itself, it is said that contractual and they are different, how could reliance be placed on it? Now, the financial repercussions of this is today 1,500 crores for these contractual employees. Now, if the COVID period is deleted, the actual delay the registry has calculated it is 344 days. So, after this review was filed, the delay was condoned, and the Gujarat High Court said this raises extremely important issues of substantial justice and technicalities have not yet come into way. Delay has been explained, please entertain the petition. And in the meantime, they also said we are staying that order, which had said give them the pay. When the first round of SLPs came before your lordship, which is the present SLP, when your lordships passed this order, which was read out to your lordships, which order effectively said, in the meantime, there shall be a stay of consequential effect of the impugned order. My lords, I say this with some sense of responsibility. In the second SLP, when I appeared, your lordships put the exact question to me, what is it that was meant and what was the object behind this? And I assisted your lordship in saying the purpose that your lordship passed that order was that in the meantime, don't start recovery proceedings against what is already being paid to those contractual agents. Keeping all that in mind, your lordships then on the next page pass this order, which is on page 19 of what is shown to your lordships. Kindly have that for a minute, my lords. Page 20 of the same application, which was read out to my lords, if your lordships were to have. The very application that my learned friend read out. Kindly for a minute have page 18 and then I'll come to 19. Please have page 18. My lords have page 18. Para 4. In the meantime, there shall be stay of consequential effect of the improved order. As we see it, and that is what we assisted your lordships, the purpose was don't start recovery proceedings while the review is on because there's a stay being passed there. So on the other set of writ petitions which came to be passed and similar orders following that Kalyan Samati came to be passed, we came in an assembly. Your lordship said, why can't you go in a review and seek review if you say Jagani and that are completely different, and consciously gave us permission, my lords. Your lordship said, appearing for the petitioner seeks permission to withdraw these petitions with liberty to file a review before the High Court, and in the event the petitioners do not succeed in the review, to approach this court again. And then we pointed out that in the light of that order, the reviews are not being heard. Your lordship said in para 4, we further clarified that the order passed by this court dated so and so would not be construed as staying review proceeding. My lords, what prejudice is caused to anyone by these reviews being heard? And I tell your lordships, I am not for a minute denying that there was delay in that council at that stage for best reasons known. Failed to explain that Jagani says exactly the opposite of what the order and the review says. Exactly the opposite of what it relies on. And if that is the result of people who are walking interview without any process, cost us 1,500 crores, surely the Gujarat.
Yes, nowadays, if you wanted to stay the order, you would have only said in the meantime we stay the order. We have said that there shall be stay to the consequences of the.
May I make this point out? Because my learned friend is saying something about what happened on that day without his actual presence. I was present. In fact, your lordships were explaining.
But then why did you word only? Why did we use the word? There has to be stay of the consequential effect.
I'm explaining my lord. Therefore, I said your parties understood all throughout, and therefore there was no movement about hearing etc. carried out by the state of Gujarat. For 1 year it happened. Look, this order at page 19, which is shown to your lordships, is an order passed in another petition in which we are not party. One thing. My learned friend trying to address something, Lord, please see the order at page 19. Because we know, Lord, what way this order, this kind of order, Lord, is passed.
No, if you wanted to stay the order, you would have used the word only we stay the order.
All this, that committee, 15,000, etc. aside, keep that aside for the present. Please see page 19. It's a matter where 15 years people have served and they have been regularized.
So therefore, all consequences, they are rightly understanding that no, there will be no recovery.
No, I'm sorry, Lord. I must point out one more thing. Lord, about 2 months before when this matter, my main matter came up for hearing, at that time I said that if they want to pursue the review for deciding the principle and for pending matters, I have no difficulty without any effect on me. My learned friend went back, take instructions. And Lord, he said that pursuant to my suggestion, they will not be recovering. This is what they are agreeing. Lord, that was not what was suggested. After realizing this, Lord, I want the matter to be placed for final disposal sometime, Lord, in coming few months. Lord, in the meanwhile, if the review petition, Lord, is heard, the very idea of your lordships entertaining the petition.
In fact, in the present application, the application is rejected.
Great, very great.
Let it be, sir. But however, it is quite clear that there shall be no recovery from.
No, I'm sorry. I just
it's not happening. I said so it is not happening. I can understand if someone comes and says it's happening.
May I suggest one thing? In that event, if you want that to be heard, your lordship may say that the order, any order passed in the review, will not be given effect at least for 8 weeks. So that will not.
We further clarify that.
Before the lordship's declared, that second complaint that yesterday I had mentioned is like I'll be obliged if your lordship's permitting. If your lordship's allow it.
I'm not instructed in this item about my. It is the same, two SLPs. Same meaning. Two SLPs. Twice on the same. Same, that's two SLPs. That's all. That's one, if your losses permit, only few things I want to say. But order of learned signature, granting benefit, division bench did not interfere. Then your lordship, SLP dismissed by your lordships. Thereafter, that order followed from time to time. Again, second round, learned signature is order, division bench is order. At least two more SLPs dismissed. So far, this matter is concerned, more than 3 years delay. Since they did not comply, we complained. Then government notification to implement this order. Generally, when the order is passed by the court, government is not to pass a government notification that implement that order. That order is passed. That benefit given to us. Some benefits not given. Thereafter, that order followed in some other matters. And while withdrawing those SLPs, they said we will file review there. Then the question, there is this question that it should not be understood that your lordship's order on this matter is coming in their way in filing those review applications. With that, they did not file those review applications first. They filed not in this matter before the High Court. That let this review be heard first. Then the court said that you have to file as review applications arising from that subsequent order, which they subsequently filed. Appropriate orders are passed therein. If they are agreed, they are coming before your lordships. And thereafter, now after 8 months, since they did not succeed in those review applications, they said that this stay has expired. Therefore, they are not requesting the court. They say that this stay has expired. Therefore, I have to move your lordships and get clarification that that stay has not expired. Now, please see only 3 dates. The order passed by your lordships on this matter is 13 June 23. Thereafter, this matter is listed on 5th November 24. First listing thereafter is 5/11/24, 19/11/24, 2nd December 24, 9th December 24, 13th December 24, and now today. No order thereafter. Now, when this SLP was not even on board, on that day, your lordships have diluted this order is the understanding of the government and the High Court, and we are asked to move your lordships that if you will not get this order clarified, we'll take that it has gone.
You are appointed on contractual basis or ad hoc basis?
Contract basis and continued for more than a decade.
When were you appointed?
There are different. And one more very glaring aspect.
2018 terminates the next division bench and your lordships confirm.
And the cause of termination was very glaring aspect.
How have the High Courts considered Uma Devi?
How
have the High Courts considered Uma Devi?
Say only one thing,
How they have considered Uma Devi? Whether after the judgment of Uma Devi, you could have been appointed on a contract basis?
No, the policy of the state. The policy of the state itself. And one more thing.
Thank you.
Only one more thing. The entire controversy started because the pendency of that petition, the High Court said that you are paying them 2,500 rupees, pay at least minimum wages. Now, since the question cropped up for minimum wages, proposal was made to government and government said that okay, High Court has suggested payment of minimum wages, terminate them. The termination basis was payment of, this is the part of record.
So High Court observed terminate them.
No. Government said, High Court said that during pendency of the petition, pay at least minimum wages. Minimum wages payment and therefore termination. Please see, kindly allow me only one time, Lord.
Yes, thank you. Thank you very much. We are not inclined to entertain the present application. However, it is made clear that in the event the review applications are allowed, However, in the event the review applications are decided by the High Court, the same shall not be given effect to for a period of 8 weeks from the date of the order. It is further made clear that the outcome of the review petitions shall be subject to the proceedings of the present proceeding.
Very great. There's already an order for fixing it for hearing something. The main fiction.
Will be considered.
After 4 weeks also,
We will consider it. Yes,
Yeah.
Yes, I am.
I am. Main matter is pending. We have said that the decision of the review will be subject to the present proceedings.
I have requested the 25,000. Let's see.
Has it been solved? Service complete?
I have service complete.
Yes, Mr. Zagi.
Charge sheet has already been filed.
No. We have issued notice to the respondent by so as to explore the possibility of settlement.
Not appeal.
Take instructions from our police station whether she is willing for mediation. Whether the London Constable of the State is when duly served, the respondent number 2 has not put in affidavit. We request the London Constable of the State to take instructions from the concerned police station as to whether the respondent wife is willing for mediation.
Put up to 4 weeks.
Put up 4 weeks, yes.
This was a watching that was entertained by the High Court. I think first time after notice, we are not able to file our counter. But should we give us some time just to put it short? So my friend has filed additional document worth more than 300 pages, which were not part of the High Court record. So they are part of some proceeding case. Permit us.
Why don't you settle the matter?
Was tried because the High Court by order dated 2023. The matter was sent to the mediation. Things happened.
We are willing. We're still willing.
Yeah.
Because it's a property, it's our office property.
Question is not if that last time what happened, I don't want to say here because it's a mediation proceeding. Sometimes we are willing to try.
Because two things are weighed with us. While issuing notice, 2 things were weighed. One, when your application for discharge was pending, still you file an application under 14.
I filed many documents, but it is not filed.
The relevant ones. So when do you want? Maybe at the request of at the request of the respondents for filing complaint.
Not averse to settlement of this matter.
Brothers fighting doesn't We'll request both of you to go with the open mind. Who? Mr. The way appears for whom? So the way appears for whom? Okay. Your client happens to be. Your clients appear to be quite wealthy.
In the parties where the parties have had business and everybody is settled very well. It's not that parties are not well settled. They're quite well settled in their own businesses. This is about something which is under an MOU, property was to be transferred, say it happened. The third party somebody filed a suit, he said after 4 years, I am under an impression that this suit was filed at your instance. I can't say anything about an impression without being created. Yes, well, and there's well to do. That's it.
We are talking about your client. If you want to amplify it further, we.
Suspension of page 107. I have already undergone about 10 years.
9 years.
8.5 years. With remission, that is 10 years. So there was
With remission, it is more than 9 years.
8 years and 5 months without remission.
Only dying declaration.
That is sufficient. 3 dying declarations are 2 years.
Whether living
Hatin Alishi is there, mothers.
Whether leave is granted.
It's only for suspension of sentence.
Yes, sir.
After notice.
Okay. Leave granted. The appeal challenges the order passed by the Learned Division, which is the High Court, by which the application for suspension of sentence is rejected. Correct. The application is vehemently opposed by the Raja, the Learned. Your age, in concept for the state of Madhya Pradesh, taking into consideration the period of incarceration and that there is no likelihood of the appeal being heard in the near future, we are inclined to allow the application.
Okay.
I'm led by the joint raised minorities on his legs in vote number 13, and we told that matter is going to go on the next week also. I'm seeking a short accommodation for 3 weeks.
Yes.
Well, I will be permitted to file rejoinder.
But after 2 weeks?
But some fixed date is.
After 2 weeks, they were to file rejoinder.
Could it be 3 weeks?
3 weeks.
And we give action.
Yes, who is happening?
Please, but I appear for the petitioner and the petitioner seeking the recovery of their salary for the period which they have actually covered. But this case has a history, I can just quickly take your lordship to the background of the case. So there were 3 vacancies of the stenographers in Saharanpur District Court. 7 people were appointed, 4 were appointed towards the vacancies as steno for the fast track courts. Later on, the notice were issued to them that saying there were only 3 vacancies, you can't continue. So our services were terminated. Since the fast track court were again established, not the district court, the administrative judge of Allahabad High Court directed the district judge to reappoint us, continue in the service. So we continued. Later on, for 7 more years we continued. Later on, our services were seized. So
services were
seized, they were terminated.
Not continued.
Yes. Our writ petition was dismissed against that order. It was appealed up to this honorable court. However, while this honorable court dismissing our SLP law, liberty was granted us to seek the recovery of our arrears of salary by way of a civil action.
Yes.
Accordingly, a representation was made by them to the district judge, please give us the salary for the period we have actually worked. Now that was declined. That the writ petition was filed by these persons before the Honorable High Court.
What happened before the civil court?
No, we didn't approach the civil.
Okay, you made a representative.
Yes, the representation, because there were no dispute as far as our period of working is concerned. And this is also acknowledged by the High Court in the writ petition law, that there is no dispute to this aspect. The only thing is this is civil action, you need to file a suit, writ petition is not a civil action.
Where is that?
Page 16, page 16 and 17, the Supreme Court. But the liberty has been granted to civil action.
Appeal lies merit. Where is the order of the learned single day?
P9, connection P9, at page 26. Got it? Gary?
Yes.
And so, this petition sought quashing of order dated so and so, further it sought for grant of constitutional benefit, including salary and other allowances, by ignoring order dated 23rd December 24, on facts which are not disputed. It is evident that the petitioner had participated in the selection process initiated by the concerned justice for the appointment of on the post of stenographers. On being selected, the petitioner received appointment letters by the district judge and also assumed charge on 16 April 2002. On 10 April 23, the district judge called upon the petitioner to show cause why their appointment be not cancelled, since they had only been made in access to the vacancies which have been advertised. On 28 February 2005, the district judge passed an order terminating the service of the petitioner. This was subjected to challenge in petition so and so, which came to be dismissed by the learned judge of this court by holding in the light of the principles enunciated in District Judge Bhagpat and another versus so and so case. The appointment of the petitioner in excess of the vacancies advertised could not be sustained. Agreed by the said decision, an intra-court appeal was deferred with matter similar fate, with the division bench dismissing the same on July 12. The matter was thereupon taken upon appeal before the Supreme Court when SLP number so and so was preferred by the petitioner. This SLP was also dismissed on 21st September 12 in the following terms. We do not see any reason to interfere in the implied order. The special petition is dismissed. Learned counsel for petitioner at this stage submits that the petitioner did not pay had not been paid the salary of 8 years.
Where is the order in SLP?
Yes, ma'am. My lord will find the order of passed by this honorable court at page
16 and 17.
16 and 17.
Yes.
My lord, Mary?
Yes, please.
We do not see any reason.
Yeah. Page 27.
Please, ma'am.
Yes.
Page 27. Learned counsel for petitioner, that's the second paragraph where I was reading. Learned counsel for petitioner at this stage submit that the petitioners were not paid salary for a period of 8 years, even though they have worked as stenographers. He seeks liberty for the petitioners. Petitioners were not paid salary for a period of 8 years, even though they have worked for stenographers. He seeks liberty for the petitioner to claim payment of salary for the period they have worked. We make it clear that the dismissal of a special petition shall not prevent the petitioners from seeking any such relief in appropriate civil action. We express no opinion as to the maintainability of any such action or the tenability of the proposed claim. Thereafter, the petitioner appear to have preferred a representation for payment of their salary.
What is this?
Civil action will be like a civil proceeding. And
Leave it.
Second thing for this issue has been settled by this honorable court and the SP by dismissed by. So again, they are raising the same thing and they went now.
They are not raising the same thing. You are appealing for the High Court of the state government. This is the manner in which you treat the employees who work in the courts.
They have worked. This is an.
You are not disputing this.
Then how can you keep the salary with you?
Yeah. Leave granted. Appeal taken up for hearing. The appeal challenges the judgment and order. The order passed by the learned division bench of the Allahabad High Court dated 16th of May 2019, by which the appeal filed by the present appellants challenging the order passed by the learned single judge of the High Court dated 23rd of May 2018 came to be dismissed. Paragraph. The facts in the case are not in dispute. The petitioners, in response to the advertisement issued by which district?
Saranpur.
The Saranpur District Court had applied for the post of stenographers. The petitioners, along with the other 6 persons in the set, who were found suitable in the set selection process and were appointed to the post of stenographer. The petitioners assumed their charges on 16th of April 2002. However, subsequently it was found that the number of posts advertised was only 3 and 4 additional persons were 4 additional persons that the petitioners were appointed in excess. The petitioners were therefore issued a show cause notice calling upon them to show cause as to why their appointment should not be cancelled. On 28th of February 2005, the district judge passed an order terminating the services of the petition. Paragraph. Being agreed by the termination, the petitioners approached the learned single judge of the Allahabad High Court by writ petition number 43168 of 2005. The same came to be dismissed. An intra-court appeal carried there against was also dismissed. Being further agreed thereby, the petitioners approached this court by an SLP. Paragraph. This court, by order dated 21st of September 2012, dismissed the SLP filed by the present petitioner in the following terms. Page 16, at least the person, the name should names you should type carefully.
I apologize for this.
You see the page 16. Correct. It pursues to the liberty granted by this court for recruitment in order. The petitioners preferred a representation to the learned district judge. The district judge Saranpur it appears that thereafter the petitioners made representation for payment of their salary for the period during which they had worked. The said representation came to be rejected. Being agreed thereby, the petitioners preferred a writ petition before the learned single judge. The same was rejected by order dated 23rd of May 2018. An intra-court appeal carried there against is also dismissed. Being agreed thereby, the present SLP. See, what is your good name, sir?
Dr. L.S. Chaudhary.
Dr. L.S.
Chaudhary.
Dr. L.S. Chaudhary, the learned counsel of the petitioner, submits that the learned single judge of the High Court as well as the division bench have taken a totally erroneous approach in rejecting the claim of the petitioner. It is submitted that it is not disputed that the petitioners had actually put in their services for 8 years or so. It is also submitted that even the High Court has accepted the position in the impugned order. The learned single judge of the High Court has accepted the position that the petitioner had actually worked for 8 years. However, the relief is denied to the petitioner on the ground that this court had observed that insofar as payment of salary is concerned, the petitioner was entitled to take recourse to an appropriate civil action. So, it is submitted that the approach of the learned single judge in non-suiting the petitioner, since the writ court was not a civil court, is totally erroneous. Correct. What is your opinion?
Vishal Bengal.
Vishal?
Bengal.
Actually, Vishal Bengal, the learned counsel appearing on behalf of the High Court, vehemently opposes the petition. He submits that the petitioners have lost up to this court in the first round of litigation. Also, he submitted that the liberty that was granted by this court was to approach a civil, to take recourse to an appropriate civil action. Also, since the petitioner, rather than filing a civil suit, had made a representation to the learned district judge, the learned district judge had rightly rejected the said claim. For the very same reasons, it is submitted that the High Court was justified in rejecting the petition of the rejecting the petition as well as the appeal of the petition. Correct. The facts in the present case are not in dispute. The petitioners had applied in pursuant to the advertisement issued by the district court. However, it appears that though at the relevant time there are only 3 regular vacancies, since fast-track courts were functioning, the petitioners were appointed to work on fast-track courts. Subsequently, on the fast-track courts ceasing to function, petitioner services appear to have been terminated. Appellant services have been postponed. While no doubt that the termination of the petitioners has been upheld by the learned single judge division bench as well as by this court in the first round. However, this court has specifically clarified that the dismissal of the special leave petition shall not prevent the petitioners from seeking any such relief in an appropriate civil action. Correct. The High Court has non-suited the petition on the ground that the appropriate civil action would meet the proceedings only before the civil court. First, the learned single judge has elaborated on as to what would amount to a civil action by referring to the advanced law lexicon. First, no doubt that the learned single judge has correctly considered the definition of a civil action, but in our view, while exercising the jurisdiction under Article 226, the court is not expected to be hyper-technical. Paragraph. The position that the petitioners had in fact put in 8 years of service is not disputed by anyone at all. Much after the judgment of the learned single judge was delivered on 23rd of May 2018, this court, in the case of Avizer International versus Swans, has held that even in case of disputed questions of fact, the High Court would be justified in entertaining a petition under Article 226 of the Constitution of India. It has been held that even in cases where there are disputed questions of fact, when such disputes can be decided on the basis of affidavit evidence and no elaborate evidence is required to be considered, the High Court would be justified in granting a relief under Article 223 paragraph. In any case, the state as well as High Courts are expected to be a model litigant. First of all, the High Court is not expected to take a hyper-technical view when dealing with the case of payment of salary of the employees of the district judge who have actually put in 8 years of service. First of all, the law laid down by this court in the case of Avizer International has been subsequently followed by this court in the cases of Swans. But in that view of the matter, we find that the judgment and order passed by the learned single judge as well as the learned division bench are not at all sustainable in law. First of all, the appeal they have followed the impugn orders related to Swans are passed in set aside. The respondents are directed to pay the salary of the petitioners for the period during which they have actually worked. The set shall be paid within a period of 3 months from today, along with the interest at the rate of 6% per annum from the date on which the salary ought to have been paid to them. Since for no reason the petitioners were required to run from one court to another, and specifically after 2012, that is the date on which the order was passed by this court, the petitioners are also entitled to costs which are quantified at rupees 1 lakh each. The cost also be paid within a period of 3 months from today. 2 lakhs each. 1 lakh.
Permission of Your Honor, I appear to be person. This matter was filed during the COVID-19.
Administrative.
This matter was filed during the Lordship, the Commission. This matter was filed during the COVID-19 period when the lawyers were not.
I think I'm not taking up your matters itself.
But Lordship may review the order. That was a long order in Bombay High Court.
You want it to be taken or you don't want it to be taken?
Lordship can take the matter. I don't have any business. Can take the matter.
My submission,
In this matter, Your Lordship, pertains to the aspect of the lawyers not having worked during COVID-19 period, and as a result of which I had asked and prayed that they should be allowed to take up other employments which are actually, though against 47, 48 and 49 of the Bar Council of India rules, but in those periods relaxation can be given.
But Mr. Chandrapal, how can we direct something to be done contrary to the statutory provisions?
No, Lordship, but then in that event, I had asked the BCCI. The reply also was not given to us.
Anyway, now it has become a question of academic interest.
Can I just make one?
And hopefully we do not have any other COVID.
Lordship, can I make one small submission?
Yes.
Lordship, thereafter in 2021, I had taken out an IA for allowing advertisements. Now, although the COVID-19 period is over, now, Your Lordship, I want to press upon some things, which I leave it for Your Lordships. I may just enthusiastically say something for the benefit of the bar. Your Lordship, nowadays, foreign firms are permitted in the profession. Then we have got a set of non-lawyers who are actually competing on a day-to-day basis with the lawyers, and they freely advertise as tax consultants, stamp duty ready referral agents, and various things, and a lot of competition is being put. Whereas the lawyer who is registered with the Bar Council has got so much of restriction on himself that little violation here and there, they can result in professional misconduct. Your Lordship, it's high time these provisions are reviewed, and I may enjoy the support of some.
Why didn't you make a representation to the law ministry and ask them to change the law?
Your Lordship may then observe. Your Lordship may observe so and dispose and may make an approval, because this is an outdated law now. We cannot have foreign concerns competing with us. We cannot have unorganized competing with us. Chartered accounting consultancy firms competing with us. And when we do something, we immediately have
you better withdraw the petition and make a representation to the appropriate authorities.
All right, Your Lordship may allow me with the liberty to withdraw, but may allow me to make a representation at the law.
Yes, exactly, you are doing it. Yes. Actually, Chandrapal, the learned counsel for the.
I mean, appearing in person.
Appearing in person, takes liberty to withdraw the petition with liberty to make an appropriate representation for the relief claimed in the petition. Are you opposing?
You know, you're claimed in the writ petition.
Claimed in the writ petition.
This is not there, but he's argued now.
Right. So Radhika, the learned counsel appearing on behalf of the Bar Council of India, does not oppose the request. The petition is therefore disposed of as withdrawn with liberty as prayed for.
Your
Lordship, may observe the representation to be made to law ministry, because I've got an NGO which has got 50-60 lawyers.
Submitted that. Those submitted that in view of the COVID era being gone past by, the relief claim in the petition have been rendered infructuous. Does not oppose the prayer for withdrawal.
Please, Your Lordship, have your pleasure.
Oblige, Your Lordship. It may be disposed of, not disposed of.
Okay. We are disposing of, allowed to withdraw.
Oblige.
Lordship, I'm appearing on behalf of the petitioner. This is an election petition. The matter has become infructuous. So it's my prayer that the question of law may be left open.
The learned counsel of the petitioner does not submit by influx of time. The petition is rendered infructuous. Dispose of as such. However, the question of law is kept upon.
I'm deeply obliged, my lord.
Lordship,
Put after 4 weeks. Who?
Lords, I'm on line minutes. I'm on line minutes. Lords, in this case, the life assured had sought permission, had obtained policies worth 55 lakhs. He defaulted in the payment of premium. The policy is therefore lapsed. He went to the district forum. District forum passes an order that there will be no refund, but he can apply for the revival of the policy. Matter goes to the State Commission. State Commission says revive the policy, and that is affirmed by the National Commission, which says that no refunds are to be made. The position is the man is now died. He expired in 2023. So there is no question of the revival of any policy. Insofar as the amounts are deposited are concerned, they were on for the period that the policy was on, his risk was covered. But technically, the petition is now, the appeal has really become infructuous in the sense that with the life assured dead, the amounts which were deposited have been used for covering his interest. Today, there is no question of the revival of an interest.
Who is appearing for the respondent? Anybody appearing?
But they were represented, but they filed a counter also. And they don't deny these facts.
Who is awake for the responder?
Online. Yes.
Better.
We will have it after some.
Very well. Very well.
Non appears for the respondent. We will have to give one more opportunity to the respondent.
Someone coming up.
Someone coming up?
Yeah, right.
Chand Qureshi is on record.
They are there.
They are waiting for P. Rajni.
Yes, Mr. Raju, what's otherwise now?
May I submit, Your Honor? May I submit, my lord? The petitioner paid about 10 lakhs for 10 policies, my lord. In the course of time, there was a due course for some policies. He offered a check, my lord. A check was dishonored. Very next day, the petitioner respondent proceeded to the branch manager, Bengal, AP, and offered to pay due policy dues in cash, but they are refused. Since now, till now, they are not received the policy premiums. Whenever the respondent proceed to pay the policy premiums.
You granted, stay confirmed.
Lordship.
So never
Grateful.
Please, Lordship. Please, Lordship. Taken violation of judgment of your Lordship Court in Arnesh Kumar. In other words, the petitioners are taken to custody without any compliance of law, beaten up mercilessly, and my lords, reports are there. The R5, R6 have filed affidavit to your Lordship Court saying that reports are correct, medical reports suggest that beaten up mercilessly. I approached the High Court for initiating contempt action. High Court dismissed by a very small order saying that one, the complaint is filed by you, FIR registered, let the investigation get over. And my lords, we can wait till such time investigation is over. Now the R5 has filed affidavit with which charge sheet is filed. The charge sheet incorporates the reports, the medical certificates, suggesting that yes, they were beaten mercilessly. And no compliance is what is admitted.
Charge sheet is filed against them.
Yes, against them. They are under suspension. The persons who were guilty of.
The action will be taken against them in accordance with law.
Your Lordships have said that in case there is no compliance of 41A, then I can approach your Lordship Court, the High Court concerned, to initiate contempt action. Now, contempt action is initiated by me, my lords, as per my law judgment.
But under contempt, at the most, we may go inside for 6 months here. They may go for 6 months.
My lords, it's just this that, my lords, the facts are such the husband files a complaint against the wife, saying that she has committed theft. And my lords, out of his instance, my lords, his sister is a prosecutor, an officer in the police station. His husband's sister, and father is the officers. Serious wounds, fractures.
Yes, is it fact?
I appear for R1 minutes, the IU.
Who appears for the
R5, R6.
who appears for the ACP and yes.
The next date we have registered the FIR, they have been suspended.
No, but do you find that the allegations made in the are correct?
Yes. Charge sheet has been filed and when the automatic inquiry has been initiated against them. In that also the charge sheet has been given under them. So everything has been done.
No, then they must go home. If they are taking the law into their hands. Law is not above everyone. And some matter the message needs to go.
We have taken the investigation. In that investigation, the MLC and everything has been taken on record. The CCTV footage also have been taken on record. Only difficulty is because it is as yet been pending. It's ongoing process.
let the process get completed.
No, but why should they disobey the direction of the court?
Discussion as far as 41A non-compliance is concerned. We have taken the action. 5 and 6 is concerned.
So now we will also take an action against them.
2 and 3 are there. They will be presented as submitted.
Page 92 by the affidavit of R5, R6 in terms record serious injuries, my lords, on the claws of the hands, fractures, spindles, thighs of the lady, my lords, thighs, forearms, very serious injuries, my lords. Fractures, my lords.
In the counter which has been filed.
Yes, my lord, by 5 and 6, my lords. The Assistant Commissioner of Police and the Deputy Commissioner of Police, my lord, that counter lordship may consider, which incorporates the charge sheet filed against the erring officers. My lords, page 90 lordship may consider first, my lords. With permission, I can mention you. My lords, on the top at 90. Second line, thereafter, I'm sorry, my lords, my apologies.
Thereafter?
Yes, my lords. They told me that they will make you naked and hang on the fan and beat if you may not admit the crime. And then both the officials started abusing in filthy language. During the assault, Rachna Sharma, the lady, the wife, started weeping loudly. Upon hearing her voice, her relatives, who were sitting outside the gate of the police station, tried to enter into the room where investigation was being done. But the constable guarding the gate prohibited them to enter into the premises and stopped them on the gate. Thereafter, both the delinquent officials brought Rachna Sharma on the ground floor. They gave her heat treatment to Rachna at the spots where she was feeling injuries. They also gave her medicine and applied cream. As the delinquent officials had mercilessly beaten Rachna Sharma, she was unable to move properly, and after coming out of the police station with her family, she went to the hospital, but because of non-availability of the doctor in the hospital, she could not be given the treatment. Then she went to her home. Now, if you may see page 91, middle of the page, in front of line 4, delinquent SI, the delinquent constable Kuldeep, started assaulting Yash, the brother of the wife, Yash Divedi, and in the meantime, the delinquent constable shown a video in his mobile phone hanging a person upside down and asked him that we will give you the same treatment. Thereafter, the delinquent SI and delinquent constable Kuldeep took Yash Divedi to the first floor room of the police station, and the delinquent constable assaulted Yash Divedi with stick, and after removing his clothes, he made him murga and continued to assault him. In the meantime, delinquent SI Surinder Singh came out of the room, but the delinquent constable Kuldeep continued to assault Yash Divedi. Thereafter, Yash was brought to the chamber of the in-charge police station, allowed to talk to the complainants, etc. Now, can you see 92 subparagraph? The investigating officer obtained the MLC report of Rachna Sharma and Yash. During the investigation, Rachna had been inflicted injuries on the claws of both her hands and spindles of the feet, thighs, forearms, which is confirmed from the facts mentioned in medical report. In regard to the injuries inflicted on Rachna Sharma, query was raised from the doctor. Doctor has clearly mentioned that the injuries inflicted on Rachna are grievous but are not danger to life. Also, the MLC report of Yash also has been got prepared. During the assault, Yash has been inflicted injuries on the thumb of his left hand, palm of the left hand, spindles of both the feet and both the hips. According to the report of the doctor, injuries are hard and blunt but were simple. From CCTV footage of so-and-so dates, in connection with the incident occurred with applicants Rachna and Yash, it appears that woman constable Arpita, who is R3 before Lordship Court, and constable Kuldeep R2 took applicant Rachna and Yash in the room in the first floor, and Akhilesh Sisodia, member so-and-so, went with a stick in his hand. Applicants were assaulted in the presence of SI Surinder Singh during the investigation. It is found from the perusal of the entire story that the applicant Rachna and Yash were taken to the room on the first floor of the police station where delinquent Kuldeep and Arpita were investigating about the property stolen, and in charge PS delinquent SI Surinder Singh was present in the police station. Relatives of Rachna
were present on the gate of the police station being so and so, their names are mentioned, is prima facie found that the presence of delinquent Surendra Singh, delinquent Kuldeep and Arpita unnecessarily beaten the applicant, which is confirmed by the report, etc., etc. Then other things are mentioned. Lordship will now see page 95. The charges leveled against Kuldeep, Arpita. On 2/7/23, the suspect Rachna Sharma and Yash, suspect in PS so and so, under the section so and so, were seriously assaulted during the investigation and they were inflicted injuries instead of using their supreme prudence to perform their duties deliberately, etc. On 2/7/23, the suspect Rachna and Yash, suspect in so and so, were not treated with tolerance, kind, etc. The same is repeated to our other accused persons, my lords. But these are the charges. My lords, and fracture on the upside of the palm is of the brother of Rachna. Absolutely, my lords, non-compliance.
You have Anish Kumar?
Yes, my lord, I have Anish, my lord. Kindly have a look at judgment at page 23 of this compilation of your lordships.
Of the same compilation?
Yes, my lords.
Same,
and the lords,
same compilation or SLP compilation?
SLP compilation, I'm sorry, my apologies. SLP compilation. 23, my lords. Annexure P1. And the relevant is at page 31, para 11, if I can place for my lord's kind consideration. Our endeavor in this judgment is to ensure that
Para
11, my lords, at 31.
Page 31.
Yes.
Yes, lordship pleases. Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and magistrate do not authorize detention casually and mechanically. In order to ensure that what we have observed above, we give the following directions. 11.1. All the state governments to instruct its police officers not to automatically arrest, that lordship may skip and also registered you, but satisfy themselves about the necessity for arrest under the parameters laid down above following from section 41. All police officers be provided with a checklist containing specified sub-clauses under section 41 1B2. Police officers shall forward the checklist duly filled in and furnish the reasons and materials which necessitated the arrest while forwarding producing the accused before the magistrate for further detention. Magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction the magistrate will authorize detention. Decision not to arrest an accused be forwarded to the magistrate within 2 weeks, which from the date of the institution of the case, with a copy of to the magistrate, which may be extended by the Superintendent of Police of the district for the reason to be recorded in writing. Notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the Superintendent of Police of the district for the reason to be recorded in writing. 11.7. Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of the court to be instituted before the High Court having territorial jurisdiction. It was para 12. I would respectfully urge to consider. We hasten to add that the direction issued should not apply to the cases under 498A or section 4, etc. in case for hand, but also such cases where offence is punishable with imprisonment for a term which is less than 7 years, etc. Now this 11.6, 11.7 is my proposition, which is not complied with.
Which is not complied with?
In this case, my lords, 11.7 is not complied. No notice under 41A is given. No sooner complaint is registered against us, we are picked up, and the police officers in their reply admit we have not complied with 41A. And we was picked up, not only picked up, given, sent to the custody and beaten mercilessly. And the High Court also will just kindly see very short order. At page 3, para 5, just 2 paragraphs, page 3, para 5 and para 6 is what the High Court says.
Yes.
London Counsel for the petitioner submits that since the respondents have acted in disobedience in the direction issued in the case of Arnesh Kumar, therefore they are liable to be prosecuted for contempt of this court. London Counsel has drawn attention to the police Prativedan dated 1/8/23 filed by the SHO Pardesi Pura before the district session judge Indore to oppose anticipatory bail in which he has denied that they were never called under the provisions of CRPC. Therefore, apprehension of arrest is baseless. In FIR 271, these applicants are not an accused persons. Therefore, prima facie, they were not called by the respondents in the investigation in the FIR. Therefore, the law laid down in Anesh Kumar will not apply. And then 6, even otherwise, an investigation in FIR 294, which I instituted, lodged in the instance of the present petitioners, is still pending. Therefore, any finding given in the contempt petition will affect the investigation and the trial, and hence no case for initiation of contempt proceedings made out. There was, kindly have a look at only one page. There was page 79. This is, my lords, reply of the IO opposing anticipatory bail application before the Sessions Court, where at 79, the paper book of the SLP, or should we just kindly see, my lords, first page 77, para 2. Para 2 at page 77. During an investigation, the applicant and her brother were called for questioning at Tilaknagar police station. Para 3, during this investigation, a complaint regarding assault was also made by the applicant and her brother in the police station, on which crime number 294 under sections 323 to 294 etc. has been registered against the policeman, which is under investigation. Well, kindly see para 5.5, para page 78. By the mere fact, this kindly note, by the mere fact that the sister of the complainant, Seema Sharma, was the prosecuting officer, it cannot be inferred. Para 5.4 at page 70. 78 actually.
By the mere fact, yes.
Yes, mere fact. That the sister of the complainant, Seema Sharma, was the prosecuting officer. It cannot be inferred that only for this reason, the police called the applicants as per her instructions and tried to fulfill the demands of Sunil Sharma and his sister by forcing them to confess in a false case by beating them up. And finally, kindly see page 79, para 5.7 and para 5.8. Although in this case, the petitioners were not called on the basis of the notice, this is what they admit. But it is not acceptable to assume that the petitioners were forced to confess in a false case just because of this 5.8. In the case, petitioners were not summoned as per the provisions of the Code of Criminal Procedure, but that is why the fear of the arrest of the petitioners on this basis alone is a clear admission in the proceeding before the court below, my lord, that this procedure is not done.
So after you are bitten up, you have filed an application for it?
Yes, I filed a complaint which is 294. That 294 is investigated and 5 and 6 is filed a counter for lordship court today, saying that charge sheet is filed. In the charge sheet, I note to lordship court from pages 90 onwards that MLC's report, medical reports are obtained by the investigating officer, and they have found that all these, I'm sorry.
To say something?
As far as 41A, notice was primarily that aspect whether 41A was not issued. I was the IU of the matter. Now the matter pertains to the husband lodging an FIR wherein the wife and his brother-in-law were caught because it was more of a family issue.
Oh.
Kindly appreciate.
Family issue, and therefore it is.
The other aspect, in fact, on 2 and 3, I'm not at all for 2 and 3 who have done the act, Millards. I'm not at all saying anything.
You were sitting there when they were beating you. You were sitting there.
In fact, if your lordship sees the FIR which they have lodged, Millards, there is no mention because I have said so.
The inquiry report says so.
Well, the inquiry
under your nose, everything is happening, and you are sitting idle.
As far as I am concerned, Millards, I had given my explanation, Millards, that I was not there.
We will consider your explanation.
And the FIR, if your lordship sees the FIR which has been lodged, Millards, it was only against 2 and 3.
Yes. The alibi. So you are so committed to your duty that you are on when you are on leave. You still happen to be in the police station. The petitioner has approach this court, being agreed by the order passed by the learned single judge of the Madhya Pradesh High Court, by which the contempt petition filed by the present petitioner has been dismissed. Paragraph. On a basis of the complaint filed by the husband of the petitioner number 1, it is the case of the petitioner that on the basis of the complaint filed by the husband of the petitioner number 1, the petitioner and respondent number 2 were called to the police station. It is a case that the response number 2, 3, and 4 mercilessly beaten the petitioner.
2 and 3 because essentially. Kuldeep and Akila.
2 and 3. Acha, sir. 2 and 3 mercilessly beat the petitioner and the petitioners in the presence of the respondent number 1, Surendra Singh. Alleging breach of the directions issued by this court in Anish Kumar, the petitioners approached the High Court on a clear statement of the SHO that the petitioners were not called the police station, and without examining the factual aspect, the learned single judge dismissed the contempt petition, hence this petition. By white order dated Swanso, we have issued notice. In response to the notice issued by this court, the respondents have filed the affidavit. Paragraph. From the affidavit filed by the respondent number 4 and 5, 5 and 6, it appears that there is substance in the allegations made by the petition. First, paragraph. When this court has issued directions so as to safeguard the rights of the citizens from being unnecessarily harassed and ill-treated, the police officers are bound to comply with the same. First, paragraph. Primarily, we are of the view that the conduct of the respondents number 1, 2, and 3 is in contempt of the directions issued by this court in the case of Anish Kumar of the Swans. Paragraph. We therefore frame charge against the Surendra Singh, Sub-Inspector of Police, Swanso, 2, Kuldeep Chaduk, other stable, and Arpita Bhadoria as under. As to why the aforesaid three officers of the police department should not be proceeded further for having committed contempt of this court by disobeying the directions issued by this court in Swans, by illegally taking the petitioners in their custody and ill-treating them. Are you accepting the notice, or should we go to them directly?
Use for 2 and 3. One is appearing. Who is appearing for 2 and 3?
It's not before we launch it. So he is doing launch.
The respondents, the appropriate respondent delegate shall appear before this court in person on 14th of April 2000, either in person or through their counsel, and answer as to why proceedings should not be taken against them, as to why they should not be held guilty for having committed contempt of this court. The Superintendent of Police shall ensure that the Registrar Director or the Registrar Judicial is directed to ensure that the notice is sought upon, the aforesaid delegate respond, the aforesaid alleged contemners through the Superintendent of Police, that state of Andhra Pradesh, prior to 1st of April.
Please, sir, you must reply to.
No, but we have to send a message.
Said this whatever looks the content was dismissed by the High Court on the ground that an FIR has been lodged in departmental inquiry.
The High Court has abdicated its jurisdiction.
Let's set aside that order.
No, we will ourselves. It's our direction, and at least you are bound by Ernest Kumar the most.
Most of us.
All of us, but he can't.
Of course he can't. Give it up. Grateful to your lordship. Immensely obliged.
He should have refused the brief.
Not for review, my lords. I'm grateful to your lordship, Stuart. Because can I request for 1 day more 15 instead of 14?
Okay, 15.
I'm grateful.
You are not here on 14.
No, I'm here, my lords. There are intervening holidays before your lordship, but I'm here, my lords. Generally declared, my friends tell me that.
No, last year it was not declared.
But then 14th is fine. I'm here.
If it is not, if 14 is declared already, you mention it on 15, we'll keep it on 20.
14 lordship, I have it on 14.
We will do it before the vacation.
Lordship, I have it on 14th. I'll be here on 14th. I'm grateful to you. Immensely obliged to your lordships.
My lord,